Regulating. Historical background. Regulating Act of 1773. 1. First. Regulating Act of 1773. 1. First step taken by the British government to control and regulate the affairs of the East India Company in India, laid the foundations of central administration in India. 2. It designated the Governor of Bengal as the Governor-General of Bengal, GGB. The first such Governor-General was Lord Warren Hastings. 3. It provided for the establishment of a Supreme Court at Calcutta, 1774, with original and appellate jurisdiction, comprising 1 Chief Justice and 3 other judges. UPSC Pre. 4. Bombay and Madras presidencies were made subordinate. Amending Act, 1781. 1. To rectify the defects of the Regulating Act of 1773, the British Parliament passed the Amending Act of 1781, also known as the Act of Settlement or Declaratory Act, 1781. 2. It exempted the Governor-General and the Council from the jurisdiction of the Supreme Court for the acts done by them in their official capacity, and also exempted the servants of the company from the jurisdiction of the Supreme Court for their official actions. 3. It excluded the revenue matters and the matters arising in the collection of revenue from the jurisdiction of the Supreme Court. 4. It provided that the Supreme Court was to have jurisdiction over all the inhabitants of Calcutta. It also required the court to administer the personal law of the defendants, i.e., Hindus were to be tried according to the Hindu law and Muslims were to be tried according to the Mohammedan law. 5. It laid down that the appeals from the provincial courts could be taken to the Governor-General in Council and not to the Supreme Court. It empowered the Governor-General in Council to frame regulations for the provincial courts and councils. Pitt's India Act, 1784. 1. Indian affairs came under direct control of the British government in Britain. Distinguished between the commercial and political functions of the company. 2. Allowed the Court of Directors, COD, to manage the commercial affairs and created a new body called Board of Control, BOC, 6 members, to manage the political affairs, to supervise and direct all operations of the civil and military government or revenues of the British. Act of 1786. 1. Lord Cornwallis was appointed as the Governor-General of Bengal. He placed 2 demands to accept that post, viz. 1. He should be given power to override the decision of his council in special cases. 2. He would also be the commander-in-chief. Accordingly, the Act of 1786 was enacted to make both the provisions. 5. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Possessions in India. Thus, it established a system of dual government. Charter Act 1793. 1. It extended the overriding power given to Lord Cornwallis over his council, to all future Governor-Generals and Governors of Presidencies. It gave the Governor-General more powers and control over subordinate presidencies of Bombay and Madras. 2. It extended the trade monopoly of the company in India for another period of 20 years. 3. It provided that the Commander-in-Chief was not to be a member of the Governor-General's Council, unless he was so appointed. 4. It laid down that the members of the Board of Control and their staff were, henceforth, to be paid out of the Indian revenues. Charter Act, 1813. 1. It ended the monopoly of the EIC in India except companies' monopoly in trade with China, and trade in tea with India. Thus, trade with India for all commodities except tea was thrown open to all British subjects. This lasted till 1833, when the next charter abolished the trade of the company. 2. It asserted the sovereignty of the British Crown over the company's territories in India. Constitutional position of British territories in India explicitly defined for first time, UPSC Pre. 2019. 3. It allowed the Christian missionaries to come to India for the purpose of enlightening the people. 4. It provided for the spread of Western education among the inhabitants of the British territories in India. 1 lakh rupee for education in native India, UPSC pre-2018. 5. It authorized the local governments in India to impose taxes on persons. They could also punish the persons for not paying taxes. Charter Act, 1833. 1. Final step towards centralization. 2. Governor-General of Bengal became the Governor-General of India. Lord William Bentinck was the first Governor-General of India. The Governor-General was vested with all civil and military powers. 3. It deprived the governors of Bombay and Madras of their legislative powers. 4. The laws made under the previous acts were known as regulations, while the laws made under this act were known as acts. It ended the activities of the EIC as a commercial body, making it a purely administrative body. 5. Introduced law member, Macaulay, in Governor-General's Council. Charter Act, 1853. 1. Separated the legislative and executive functions of the Governor-General's Council. Separation of powers. 2. Provided for addition of 6 new members called legislative councillors to the council known as the Indian Central Legislative Council. 3. It introduced, for the first time, local representation in the Indian Central Legislative Council. 4. Introduced an open competition for civil services. The Covenant civil service was thus thrown open to the Indians also. 5. Governor-General could veto bill. 6. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. 6. Provision for open competition negated by this act. 7. Restrictions on immigration of Europeans and acquire property were lifted. 8. Indians law codified and consolidated. 9. No Indian denied employment under company on the basis of religion, color. 10. Abolished slavery. Government of India Act, 1858. 1. Also known as the Act for the Good Government of India. 2. Rule of company was replaced by the rule of crown. 3. Changed the designation of the Governor-General of India to that of Viceroy of India. Viceroy became the agent of the Crown. 4. This act abolished the dual government of the Pitt's India Act. 5. This act also ended the doctrine of lapse. 6. The Secretary of State was a member of the British Cabinet and was ultimately responsible to the British Parliament. Established a 15-member Council of India to assist the Secretary of State for India. 7. Secretary of State can be sued in India and in England. Indian Councils Act, 1861. 1. Initiated the process of decentralization by restoring legislative powers to Bombay and Madras. These powers were taken away through Charter Act. 1833. 2. Introduced representative institutions in India by associating Indians with the law-making process. 3. Viceroy nominated some Indians as non-official members of his expanded council. 3 Indians nominated were the Raja of Benares, the Maharaja of Patiala, and Sir Dinka Rao. Indian Councils Act, 1892. 1. Though the majority of official members were retained, the non-official members of the Indian Legislative Council were henceforth to be nominated by the Bengal Chamber of Commerce and the provincial legislative councils, while the non-official members of the provincial council were to be nominated by certain local bodies such as universities, district boards and municipalities. Beginning of representative system in India. Indirect elections. 2. Council to have the power to discuss budget and of addressing questions to the executive. 7. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. 4. It empowered the Viceroy to issue ordinances during emergency. 5. Empowered the Viceroy to frame the rules of business. The same power is given to the President of India under Art. 77. 6. New legislative councils for Bengal, NWFP, Punjab. 7. Statutory recognition to portfolio system, introduced by Lord Canning, UPSC Pre. Indian Councils Act, 1909, Morley-Minto reforms. 1. Introduced for the first time, an element of elections to the legislative councils, at the provincial legislative councils, non-official members to be in majority. 2. Introduction of separate electorates, for Muslims. 3. Representation in excess of population accorded to Muslims. 4. Income qualification low for Muslim voters. 5. It provided for the first time, association of Indians with the executive councils of the Viceroy and governors. Sachendra Prasad Sinha became the first Indian to join the Viceroy's executive council. He was appointed as the law member. Government of India Act, 1919, Montagu-Chelmsford reforms. 1. Responsible government. 2. Office of the High Commissioner of India was created in London. 3. Indian legislature became bicameral, for the first time, centre. 4. Communal representation extended to Sikhs, Christian, Anglo-Indian, Muslims. 5. Secretary of State for India now to be paid from British revenue. 6. Diarchy in provinces transferred subjects, governor with ministers responsible, reserved subjects governor with executives. 7. Devolution of legislative authority by centre to provinces separating central and provincial subjects, UPSC Pre-2012, Indian Independence Act, 1947. The 20th of February 1947 Attlee declared British rule end by the 30th of June, 1948, the 3rd of June 1947 Mountbatten Plan accepted. Government of India Act, 1935. 1. Provided for the establishment of an All India Federation consisting of provinces and princely states as units. Note: princely states did not join and so federation didn't come into existence. 2. Residuary powers were given to the Viceroy, Governor-General, UPSC 2018. 3. Abolished diarchy in the provinces and introduced provincial autonomy in its place. UPSC Pre-2000. 4. Introduced responsible government in provinces. 5. Introduced bicameralism in 6 out of 11 provinces. 1. Declared India as an independent and sovereign state from August 15, 1947. 2. Provided for creation of 2 independent dominions of India and Pakistan with the right to secede from the British Commonwealth. Governor-General of each were to be appointed by King, on advice of the Dominion Cabinet. 3. Empowered the constituent assemblies of the 2 dominions to frame and adopt any constitution and to repeal any act of the British Parliament, including the Independence Act itself. 4. Abolished the office of the Secretary of State for India and transferred his functions to the Secretary. 8. Telegram. https://t.me/IAS Network website, www.IAS. Network contact, 9,779,726,117. 6. Extended the principle of communal representation by providing separate electorates for depressed classes, scheduled castes, women and labor workers. 1909 only for Muslims, 1919 extended for Sikhs, Indian Christians, Anglo-Indians and 7. Europeans. Abolished the Council of India, established by the Government of India Act of 1858. 8. The Secretary of State for India was provided with a team of advisors. 9. Established the Reserve Bank of India to control the currency and credit of the country. 10. Established the Federal Public Service Commission, Provincial Public Service Commission and Joint Public Service Commission for 2 or more provinces. 11. Federal Court, which was set up in 1937. Of State for Commonwealth Affairs. It assigned dual functions, i.e. constituent and legislative, to the Constituent Assembly formed in 1946. It declared this Dominion legislature as a sovereign body. Granted freedom to the Indian princely states either to join the Dominion of India or Dominion of Pakistan or to remain independent. Making of Constitution. Field Circle 1934 idea of a Constituent Assembly for India was put forward for the first time by M.N. Roy, a pioneer of communist movement in India. Field Circle 1935 the Indian National Congress, Inc., for the first time, officially demanded a Constituent Assembly to frame the Constitution of India. Field Circle 1938 Nehru declared Constitution must be framed, without outside interference, by a Constituent Assembly elected on the basis of adult franchise. Field Circle 1940 August offer, demand for Constitution accepted. Field Circle 1942 Sir Stafford Cripps, a member of the Cabinet, came to India with a draft proposal of the British government on the framing of an independent constitution to be adopted after the World War II, proposal rejected by Muslim League. Field Circle 1946 Constituent Assembly was constituted in November 1946 under the scheme formulated by the Cabinet Mission Plan. Field Circle the Constituent Assembly was to be a partly elected and partly nominated body. Moreover, the members were to be indirectly elected by the members of the provincial assemblies, who themselves were elected on a limited franchise. UPSC pre-2013. Field Circle Assembly comprised representatives of all sections of the Indian society: Hindus, Muslims, Sikhs, Parsis, Anglo-Indians, Indian Christians, SCs, STs including women of all these sections. 9. Telegram, https://t.me/IAS Network website, www.IAS, Network contact, 9,779,726,117. Field Circle 9 December, 1946 First meeting of Assembly, Muslim League boycotted the meeting, Shindra Sinha made temporary president, French practice. Field Circle the 11th of December 1946 Rajendra Prasad was elected as the president of the Assembly. Similarly, both H.C. Mukherjee and V.T. Krishnamachari were elected as the vice presidents of the Assembly. Field Circle the 13th of December 1946 Jawaharlal Nehru moved the historic Objectives Resolution, Philosophy of Constitution Structure, in the Assembly. Field Circle the 22nd of January, 1947 Resolution adopted. Field Circle the 3rd of June 1947 Mountbatten Plan. Field Circle Indian Independence Act of 1947 Assembly was made a fully sovereign body. Assembly also became a legislative body. The Assembly became the first Parliament of Free India, Dominion legislature. Field Circle whenever the Assembly met as the constituent body it was chaired by Dr. Rajendra Prasad, and when it met as the legislative body, it was chaired by G.V. Mavlankar. These two functions continued till November 26, 1949. Field Circle Constituent Assembly also performed the following functions. 1. It ratified India's membership of the Commonwealth in May 1949. 2. It adopted the national flag on July 22, 1947. 3. It adopted the national anthem on January 24, 1950. 4. It adopted the national song on January 24, 1950. 5. It elected Drive Rajendra Prasad as the first President of India on January 24, 1950. Field Circle the Constitution as adopted on November 26, 1949, contained a preamble, 22 parts, 395 articles and 8 schedules. The preamble was enacted after the entire Constitution was already enacted. Filled circle some provisions of the Constitution pertaining to citizenship, elections, provisional parliament, temporary and transitional provisions, and short title contained in Articles 5, 6, 7, 8, 9, 60, 324, 366, 367, 379, 380, 388, 391, 392 and 393 came into force on November 26, 1949, itself filled circle Major Committees Drafting Committee B.R. Ambedkar Steering Committee Rajendra Prasad Union Powers Committee, Jawaharlal Nehru Union Constitution Committee Jawaharlal Nehru Provincial Constitution Committee Sardar Patel Drafting Committee Filled Circle Drafting Committee set up on August 29, 1947. Filled Circle. It consisted of 7 members. They were 1. Dr. B.R. Ambedkar, Chairman. 2. N. Gopalaswamy Iyengar. 3. Aladi Krishnaswamy Iyer. 4. Dr. K. M. Munshi. 5. Syed Muhammad Sadullah. 6. N. Madhava Rao, he replaced B.L. Mitter, who resigned due to ill health. 7. T.T. Krishnamachari, he replaced D.P. Khaitan, who died in 1948. 10. Telegram https://t.me/IAS Network website www.IAS Network contact 9,779,726,117 Salient features of Constitution 1. Lengthiest written constitution. Originally, 1949, the Constitution contained a preamble, 395 articles, divided into 22 parts, and 8 schedules. 2. Drawn from various sources, the Constitution of India has borrowed most of its provisions from the constitutions of various other countries as well as from the Government of India Act of 1935. 3. Blend of rigidity and flexibility. A rigid constitution is one that requires a special procedure for its amendment, as for example, the American Constitution. A flexible constitution, on the other hand, is one that can be amended in the same manner as the ordinary laws are made, as for example, the British Constitution. The Constitution of India is neither rigid nor flexible, but a synthesis of both. 4. Federal system with unitary bias. Art. 1 defines union of states and not federation of states. Usual features of a federation, viz. 2 governments, division of powers, written constitution, supremacy of constitution, rigidity of constitution, independent judiciary and bicameralism. Unitary or non-federal features, viz. a strong center, single constitution, single citizenship, flexibility of constitution, integrated judiciary, appointment of state governor by the center, all India services, emergency provisions. The parliamentary system is also known as the Westminster model of government, responsible government and cabinet government. Even though the Indian parliamentary system is largely based on the British pattern, there are some fundamental differences between the two. For example, the Indian Parliament is not a sovereign body like the British Parliament. Further, the Indian state has an elected head, republic, while the British state has hereditary head, monarchy. 5. Parliamentary form of government. Executives remain responsible to legislature, UPSC pre-2017. 6. Synthesis of parliamentary sovereignty and judicial supremacy. Doctrine of sovereignty of Parliament is associated with the British Parliament, while the principle of judicial supremacy with that of the American Supreme Court. 7. Integrated and independent judiciary. Single system of courts enforces both the central laws as well as the state laws, unlike in USA, where the federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. 8. Single citizenship. Though the Indian Constitution is federal and envisages a dual polity, center and states, it provides for only a single citizenship, that is, the Indian citizenship. Sources of the Constitution at a glance. Sources features borrowed 1. Government of India Act of 1935 Federal Scheme, Office of Governor, Judiciary, Public Service. Commissions, Emergency Provisions and Administrative Details. 11. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Distribution of powers between centre and states in Indian Constitution. 2. British Constitution. Parliamentary government, rule of law, legislative procedure, single citizenship, cabinet system, prerogative writs, parliamentary privileges and bicameralism. 3. U.S. Constitution. Fundamental rights, independence of judiciary, judicial review, impeachment of the President, removal of Supreme Court and High Court judges and post of Vice President. 4. Irish Constitution. Directive principles of state policy, nomination of members to Rajya Sabha, and method of election of President. 5. Canadian Constitution. Federation with a strong centre, vesting of residuary powers in the centre, appointment of state governors by the centre, and advisory jurisdiction of the Supreme Court. 6. Australian Constitution. Concurrent list, freedom of trade, commerce and intercourse, and joint sitting of the two houses of Parliament. 7. Weimar Constitution of Germany. Suspension of fundamental rights during emergency. 8. Soviet Constitution, USSR, now Russia. 9. French Constitution. Fundamental duties and the ideal of justice, social, economic and political, in the preamble. Republic and the ideals of liberty, equality and fraternity in the preamble. 10. South African Constitution. Procedure for amendment of the Constitution and election of members of Rajya Sabha. 11. Japanese Constitution. Procedure established by law. Preamble of Constitution. Filled Circle. American Constitution was the first to begin with a preamble. Filled Circle. Preamble to the Indian Constitution is based on the Objectives Resolution, drafted and moved by Pandit Nehru, and adopted by the Constituent Assembly. Filled Circle. Preamble reflects mind of Constitution makers, UPSC pre-2017. Filled Circle. It has been amended by the 42nd Constitutional Amendment Act, 1976, which added 3 new words: socialist, secular and integrity. Key words in the preamble. 1. Sovereign. Sovereign implies that India is neither a dependency nor a dominion of any other nation, but an independent state free to conduct its own affairs, both internal and external. 2. Socialist. Filled Circle. Congress Party itself adopted a resolution to establish a socialistic pattern of society in its Avadi session. Filled Circle. Indian brand of socialism is a democratic socialism, and not a communistic socialism, also known as state socialism. 12. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled Circle. Democratic socialism holds faith in a mixed economy, where both public and private sectors coexist side by side. Filled Circle. Indian socialism is a blend of Marxism and Gandhism, leaning heavily towards the Gandhian socialism, stateless society, UPSC pre-2020. 3. Secular. Filled Circle. Added by the 42nd Constitutional Amendment Act of 1976. Filled Circle. Positive concept of secularism, i.e., all religions in our country, irrespective of their strength, have the same status and support from the state. 4. Democratic. Filled Circle. Doctrine of popular sovereignty, that is, possession of supreme power by the people. It calls into activity the intelligence and character of ordinary man and women, UPSC 2017. Filled circle direct democracy. The people exercise their supreme power directly, as is the case in Switzerland. 4 devices of direct democracy, namely, referendum, initiative, recall and plebiscite. Filled circle referendum is a procedure whereby a proposed legislation is referred to the electorate for settlement by the direct votes. Initiative is a method by means of which the people can propose a bill to the legislature for enactment. Recall is a method by which the voters can remove a representative or an officer before the expiry of his term, when he fails to discharge his duties properly. Plebiscite is a method of obtaining the opinion of people on any issue of public importance. It is generally used to solve territorial disputes. Filled circle indirect democracy. On the other hand, the representatives elected by the people exercise the supreme power and thus carry on the government and make the laws for e.g. India. Filled circle. The principles of liberty, equality and fraternity are not to be treated as separate items in a trinity. They form a union of trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. 5. Republic. Filled circle. The head of the state is always elected directly or indirectly for a fixed period, e.g., USA. Filled circle. India has an elected head called the President. He is elected indirectly for a fixed period of 5 years. Filled circle. A republic also means 2 more things: vesting of political sovereignty in the people and not in king. Second, the absence of any privileged class and hence all public offices being open to every citizen without any discrimination. 6. Justice. The ideal of justice, social, economic and political, has been taken from the Russian Revolution, 1917. 13. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. 7. Liberty. Liberty means the absence of restraints on the activities of individuals, and at the same time, providing opportunities for the development of individual personalities, UPSC 2019. The preamble secures to all citizens of India liberty of thought, expression, belief, faith and worship, UPSC pre-2017. 8. Equality. Absence of special privileges to any section of the society, and the provision of adequate opportunities for all individuals without any discrimination. 9. Fraternity. Sense of brotherhood to assure 2 things: the dignity of the individual and the unity and integrity of the nation. Word integrity has been added to the preamble by the 42nd Constitutional Amendment, 1976. Preamble as part of the Constitution. Beriberi Union Case. 1960, Supreme Court specifically opined the preamble is not a part of the Constitution. Kesavananda Bharati. Case, 1973, held the preamble is a part of the Constitution. LIC of India Case, 1995, the Supreme Court again held that the preamble is an integral part of the Constitution. Status of preamble. Filled circle. Like any other part of the Constitution, the preamble was also enacted by the Constituent Assembly, but, after the rest of the Constitution was already enacted, independent. Filled circle. The preamble is neither a source of power to legislature nor a prohibition upon the powers of legislature. Filled circle. It is non-justiciable, that is, its provisions are not enforceable in courts of law. UPSC pre-2020. Amenability of the preamble. Filled circle. Preamble can be amended, subject to the condition that no amendment is done to the basic features. The fundamental features of the Constitution as contained in the preamble cannot be altered by an amendment under Article 368. Filled circle. Preamble has been amended only once so far, in 1976, by the 42nd Constitutional Amendment Act, which has added 3 new words: socialist, secular and integrity to the preamble. Union and its territory. Union of States. Filled circle. Article 1 describes India, that is, Bharat, as a Union of States rather than a Federation of States. Filled circle. First schedule of Constitution lists the names of states and their territories. Filled circle. Phrase, Union of States has been preferred to Federation of States for two reasons. 1. The Indian Federation is not the result of an agreement among the states like the American Federation, and 2. The states have no right to secede from the Federation. Indian Federalism UPSC pre-2017. 14. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled circle. According to Article 1, the territory of India can be classified into three categories. 1. Territories of the states. 2. Union territories. 3. Territories that may be acquired by the Government of India at any time. Filled circle. Names of states and union territories and the territorial extent are mentioned in the first schedule of the Constitution. Article 1 describes India, that is, Bharat, as a union of states rather than a federation of states. This provision deals with two things: 1. Name of the country, and 2. Type of polity. Article 2 grants two powers to the Parliament: a. The power to admit into the Union of India new states, and b. The power to establish new states. The first refers to the admission of states which are already in existence, while the second refers to the establishment of states which were not in existence before. Article 3 Parliament 2. Form a new state by separation of territory from any state or by uniting two or more states or parts of states or by uniting any territory to a part of any state. b. Increase the area of any state. c. Diminish the area of any state. d. Alter the boundaries of any state, and e. Alter the name of any state. Filled circle. Above changes can be introduced in the Parliament only with the prior recommendation of the President. Filled circle. President has to refer the same to the state legislature concerned for expressing its views within a specified period. Filled circle. Power of Parliament to form new states includes the power to form a new state or union territory by uniting a part of any state or union territory to any other state or union territory. Filled circle. President, or Parliament, is not bound by the views of the state legislature. Filled circle. Constitution authorizes the Parliament to form new states or alter the areas, boundaries or names of the existing states without their consent. Filled circle. India is rightly described as an indestructible union of destructible states. Article 4 Filled circle declares that laws made for admission or establishment of new states, under Article 2, and formation of new states and alteration of areas, boundaries or names of existing states, under Articles 3, are not to be considered as amendments of the Constitution under Article 368. Filled circle. Such laws can be passed by a simple majority and by the ordinary legislative process. 15. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Various commissions in evolution of states and UT.S. DA Commission. Filled circle. For reorganization of states on linguistic basis. Accordingly, in June 1948, the Government of India appointed the Linguistic Provinces Commission under the chairmanship of S.K. DA to examine the feasibility. Filled circle. The Commission submitted its report in December 1948, and recommended the reorganization of states on the basis of administrative convenience rather than linguistic factor. JVP Committee. Filled circle. It consisted of Jawaharlal Nehru, Vallabhbhai Patel and Patabi Sitaramaiah and hence, was popularly known as JVP Committee. Filled circle. Constituted in December 1948, submitted its report in April 1949, and formally rejected language as the basis for reorganization of states. Filled circle. However, in October 1953, the Government of India was forced to create the first linguistic state, known as Andhra state, by separating the Telugu-speaking areas from the Madras state. Faisal Ali Commission filled circle December, 1953 a three-member states reorganization commission under the chairmanship of Faisal Ali. Its other two members were K.M. Panikkar and H.N. Kunzru filled circle submitted its report in September 1955 and broadly accepted language as the basis of reorganization of states. Filled circle it rejected the theory of one language one state. Filled Circle Commission suggested the abolition of the four-fold classification of states and territories. States Reorganization Act, 1956, new states and union territories created after 1956. 1956 Kerala equals Travancore plus Kochi plus South Kannada Andhra Pradesh equals Andhra plus Hyderabad Madhya Pradesh equals Madhya Bharat plus Vindhya plus Bhopal. New UT equals Lakshadweep, Minikoi, Amandivi Islands from the territory detached from the Madras state. 1960 Maharashtra and Gujarat bifurcated. 1961 Dadra and Nagar Haveli, 10th Const. AMD. 1962 Goa, Daman, DU, 12th Const. AMD. French handover Puducherry, 14th Const. AMD. 1963 Nagaland. 16. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. 1966 Haryana. 1971 Himachal Pradesh. 1974 Sikkim, 36th AMD. Sikkim full-fledged state, 1987 Mizoram, Arunachal Pradesh, Goa 2000 Chhattisgarh, Uttarakhand, Jharkhand 2014 Telangana. 2019 Two Union Territories J&K, Ladakh Jammu and Kashmir Reorganization Act, 2019, bifurcated the erstwhile state of Jammu and Kashmir into two separate union territories, namely, the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. Citizenship. Rights only to citizens. Rights to aliens. Filled circle they enjoy all civil and political rights. Filled circle 1. Right against discrimination on grounds of religion, race, caste, sex or place of birth. Article 15. 2. Right to equality of opportunity in the matter of public employment. Article 16. 3. Right to freedom of speech and expression, assembly, association, movement, residence and profession. Article 19. 4. Cultural and educational rights. Articles 29 and 30. 5. Right to vote in elections to the Lok Sabha and State Legislative Assembly. 6. Right to contest for the membership of the Parliament and the state legislature. 7. Eligibility to hold certain public offices, that is, President of India, Vice President of India, Judges of the Supreme Court and the High Courts, Governor of States, Attorney General of India and Advocate General of States. Filled circle aliens are the citizens of some other state and hence, do not enjoy all the civil and political rights. Filled circle all other rights except Article 15, 16, 19, 29, 30. Are enjoyed by aliens. Filled circle however enemy aliens do not enjoy protection against arrest and detention. Article 22. Note: in India both a citizen by birth as well as a naturalized citizen are eligible for the office of president, while in USA, only a citizen by birth and not a naturalized citizen is eligible for the office of president. British citizens staying in India cannot claim right to freedom of trade and profession, UPSC pre-1999. 17. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Constitutional provisions, citizenship from Articles 5 to 11 under Part 2. Filled circle it only identifies the persons who became citizens of India at its commencement, i.e., on January 26, 1950. Filled circle neither any permanent nor any elaborate provisions. Filled circle it does not deal with the problem of acquisition or loss of citizenship subsequent to its commencement. Filled circle empowers the Parliament to enact a law on matter relating to citizenship. Following four categories of persons became the citizens of India at its commencement, i.e., on January 26, 1950. Article 5 Person who had his domicile in India and also fulfilled any one of the three conditions, viz. 1. If he was born in India. 2. Or if either of his parents was born in India. 3. Or if he has been ordinarily resident in India for 5 years immediately before the commencement of the Constitution, became a citizen of India. Article 6 A person who migrated to India from Pakistan, if he or either of his parents or any of his grandparents was born in undivided India and also fulfill any of two conditions. 1. He migrated to India before July 19, 1948. He had been ordinarily resident in India since the date of his migration. 2. He migrated to India before July 19, 19481. He had been ordinarily resident in India since the date of his migration, residence for 6 months before registration. Article 7 A person who migrated to Pakistan from India after March 1, 1947 returned to India for resettlement. He had to be resident in India for 6 months preceding the date of his application. Article 8 provision covers the overseas Indians who may want to acquire Indian citizenship, persons of Indian origin residing outside India. Citizenship ACT, 1955. Acquisition of citizenship, loss of citizenship. 1. By birth. Filled circle a person born in India on or after January 26, 1950 but before July 1, 1987 is a citizen of India by birth. Filled circle born in India on or after July 1, 1987, citizen only if either of his parents is a citizen of India at the time of his birth. Filled circle born in India on or after December 3, 2004 are considered citizens of 1. By renunciation. Filled circle any citizen of India of full age and capacity can make a declaration renouncing his Indian citizenship. Filled circle if such a declaration is made during a war in which India is engaged, its registration shall be withheld by the central government. Filled circle when a person renounces his Indian citizenship, every minor child of that person also loses Indian citizenship. However, when 18. Telegram https://t.me/IAS Network website www.IAS Network contact 9,779,726,117. India only if both of their parents are citizens of India. No children of foreign diplomats posted in India and enemy aliens cannot acquire Indian citizenship by birth. 2. By descent. Filled circle person born outside India on or after January 26, 1950 but before December 10, 1992 is a citizen of India by descent, if his father was a citizen of India at the time of his birth. Filled circle December 3, 2004 onwards, a person born outside India shall not be a citizen of India by descent, unless his birth is registered. 3. By registration. On an application, register as a citizen of India any person, not being an illegal migrant, if he belongs. Filled circle ordinarily resident in India for 7 years. Filled circle person who is married to a citizen of India and is ordinarily resident in India for 7 years. Filled circle registered as an overseas citizen of India cardholder for 5 years, and who is ordinarily resident in India for 12 months before making an application for registration. 4. By naturalization. On an application, grant a certificate of naturalization to any person, not being an illegal migrant, if he filled circle not a subject or citizen of any country where citizens of India are prevented from becoming subjects or citizens. Filled circle he undertakes to renounce the citizenship of origin country in the event of his application for Indian citizenship being accepted. Filled circle resided in India or been in the service of a government in India. Such a child attains the age of 18, he may resume Indian citizenship. 2. By termination. Filled circle when an Indian citizen voluntarily, consciously, knowingly and without duress, undue influence or compulsion, acquires the citizenship of another country, his Indian citizenship automatically terminates. Filled circle does not apply during a war in which India is engaged. 3. By deprivation. It is a compulsory termination of Indian citizenship by the central government, if a. The citizen has obtained the citizenship by fraud. b. The citizen has shown disloyalty to the Constitution of India. c. The citizen has unlawfully traded or communicated with the enemy during a war. d. The citizen has, within 5 years after registration or naturalization, been imprisoned in any country for 2 years, and e. The citizen has been ordinarily resident out of India for 7 years continuously. Overseas citizenship of India. Filled circle in September 2000, the Government of India, Ministry of External Affairs, had set up a high-level committee on the Indian diaspora under the chairmanship of L.M. Singh v. Filled circle. It recommended the amendment of the Citizenship Act, 1955, to provide for grant of dual citizenship to the persons of Indian origin, PIOs, belonging to certain specified countries. Filled circle Citizenship Amendment Act, 2005, expanded the scope of grant of OCI for PIOs of all countries except Pakistan and Bangladesh as long. 19. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled circle. He is of good character. Filled circle. Adequate knowledge of a language specified in the 8th schedule. 5. By incorporation of territory, for example, when Pondicherry became a part of India. 6. Special provisions as to citizenship of persons covered by the Assam Accord, which related to the foreigners issue. Filled circle. All persons of Indian origin who came to Assam before the January 1, 1966 from Bangladesh who have been ordinarily residents in Assam since the date of their entry into Assam shall be deemed to be citizens. Filled circle. Who came to Assam on or after January 1, 1966 but before March 25, 1971 from Bangladesh and who has been ordinarily resident in Assam since the date of his entry into Assam and who has been detected to be a foreigner shall register himself as their home country's all dual citizenship under their local laws. OCI is not actually a dual citizenship as the Indian Constitution forbids dual citizenship or dual nationality. Article 9. Filled circle. The OCI card scheme was introduced on December 2, 2005. Filled circle. The Citizenship Amendment Act, 2015, replaced the nomenclature of Overseas Citizen of India with that of Overseas Citizen of India Cardholder, OCIC. Comparing NRI, PO and OCI cardholder. Non-resident Indian, NRI, person of Indian origin, PO, Overseas Citizens of India, OCI, cardholder. An Indian citizen who is ordinarily residing outside India and holds an Indian passport. A person who or whose any of ancestors was an Indian national and who is presently holding another country's citizenship, nationality, i.e. he, she is holding foreign passport. A person registered as Overseas Citizen of India, OCI, cardholder under the Citizenship Act, 1955. All benefits is available to Indian citizens subject to notifications issued by the government from time to time. No visa required. No specific benefits. Activity as per the type of visa obtained. 1. Multiple lifelong visa for visiting India for any purpose, require a special permission to undertake research work in India. 20. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. All activities. He, she is an Indian citizen. As per the Citizenship Act, 1955, he, she has to be ordinarily resident in India for a period of 7 years before making an application for registration. 2. Exemption from registration with Foreigners Regional Registration Officer, FRRO. 3. Parity with non-resident Indians, NRIs, in respect of all facilities available to them in economic, financial, and educational fields except in matters relating to the acquisition of agricultural or plantation properties. 4. Treated at par with non-resident Indians in the matter of inter-country adoption of Indian children. 5. Treated at par with resident Indian nationals in the matter of tariffs in airfares in domestic sectors in India. Fundamental Rights, Part 3, Art. 12 to 35. Field Circle fundamental rights are enshrined in Part 3, described as the Magna Carta of India, of the Constitution from Articles 12 to 35, derived inspiration from the Constitution of USA, i.e., Bill of Rights. Field Circle fundamental rights are meant for promoting the ideal of political democracy. Field Circle protect the liberties and freedoms of the people against the invasion by the state, operate as limitations on the tyranny of the executive and arbitrary laws of the legislature, UPSC 2017 FR claims of citizens against state. Features of fundamental rights. Field Circle some of them are available only to the citizens while others are available to all persons. Whether citizens, foreigners or legal persons like corporations or companies. Field Circle they are not absolute but qualified. The state can impose reasonable restrictions on them. Field Circle all of them are available against the arbitrary action of the state. Some of them are also against the actions of private individuals. Field Circle some of them are negative in character, that is, place limitations on the authority of the state. Field Circle they are justiciable. Field Circle they are not sacrosanct or permanent. The Parliament can curtail or repeal them but only by a constitutional amendment act and not by an ordinary act. Field Circle they can be suspended during the operation of a national emergency except the rights guaranteed by Articles 20 and 21. Further, the 6 rights guaranteed by Article 19 can be suspended only when emergency is declared on the grounds of war or external aggression. Field Circle their application can be restricted while martial law is in force in any area. Definition of state. Even a private body or an agency working as an Field Circle. Article 12 has defined the term for the purposes of Part 3. Field Circle state includes executive and legislative organs of the Union government, executive and legislative organs of state. 21. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Instrument of the state falls within the meaning of the state, under Article 12. Government, all local authorities, that is, municipalities, panchayats, district boards, improvement trusts, all other authorities, that is, statutory or non-statutory authorities like LIC, ONGC, SAIL, etc. Laws inconsistent with fundamental rights. Field Circle Article 13 declares that all laws that are inconsistent with or in derogation of any of the fundamental rights shall be void, provides for the doctrine of judicial review. Field Circle term, law, in Article 13, permanent laws enacted by center and state, temporary ordinance by president, statutory instruments of delegated legislation, executive legislation, like order. Field Circle the Supreme Court held in the Kesavananda Bharati case. 1973, that a constitutional amendment can be challenged on the ground that it violates a fundamental right that forms a part of the basic structure of the Constitution and hence, can be declared as void. 1. Right to equality, Art. 14-18. Article 14, equality before law and equal protection of laws. Filled circle state shall not deny to any person equality before the law or the equal protection of the laws. Filled circle concept of equality before law is of British origin. Sad face, negative concept. Filled circle, it is an element of the concept of rule of law, propounded by A.V. Dicey, the British jurist. Filled circle Supreme Court held that the rule of law, as embodied in Article 14, is a basic feature of the Constitution. Filled circle British Constitution is result of rights of individuals defined by courts and not a source of rights. In the Indian system, the Constitution is the source of the individual rights. A. The absence of any special privileges in favor of any person, UPSC 2017. B. The equal subjection of all persons to the ordinary law of the land administered by ordinary law courts, and C. No person is above the law. Filled circle concept of equal protection of laws has been taken from the American Constitution, positive concept. A. The equality of treatment under equal circumstances, both in the privileges conferred and liabilities imposed by the laws. B. The similar application of the same laws to all persons. C. The like should be treated alike without any discrimination. Filled circle exceptions to equality. The rule of equality before law is not absolute. President, Member of Parliament, Member of state legislatures, foreign diplomats who enjoy immunities, protections, and special privileges. 22. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Article 15. Prohibition of discrimination on certain grounds. Filled circle state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, or place of birth. Filled circle word only connotes that discrimination on other grounds is not prohibited. Filled circle no citizens shall be prohibited from using general public use properties maintained partly or fully by state fund. This provision prohibits discrimination both by the state and private individuals. Filled circle exceptions. State is permitted to make any special provision for women and children, socially and educationally backward citizens in education institutes, economically weaker sections, SC, Street. Article 16. Equality of opportunity in public employment. Filled circle provides for equality of opportunity for all citizens in matters of employment or appointment to any office under the state. Filled circle no discrimination for employment under state on grounds of only religion, race, caste, sex, descent, place of birth or residence. Filled circle exceptions. 1. Parliament can prescribe residence as a condition for certain employment or appointment in a state or union territory or local authority. 2. Reservation of appointments or posts in favor of any backward class that is not adequately represented. 3. 103rd Amendment Act of 2019. In order to give effect to this provision, the central government issued an order, in 2019, providing 10% reservation to the economically weaker sections, EWSs, in civil posts and services in the Government of India. Article 17. Abolition of untouchability. UPSC 2020. Filled circle Article 17 abolishes untouchability, and forbids its practice in any form. Filled circle the term, untouchability, has not been defined either in the Constitution or in the Act. Filled circle Supreme Court held that the right under Article 17 is available against private individuals. Article 18. Abolition of titles. Filled circle it prohibits the state from conferring any title, except a military or academic distinction, on anybody, whether a citizen or a foreigner. Filled circle it prohibits a citizen of India from accepting any title from any foreign state. Filled circle. A foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of the President. Filled circle. No citizen or foreigner holding any office of profit or trust under the state is to accept any present, emolument or office from or under any foreign state without the consent of the President. 23. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled circle. Supreme Court upheld the constitutional validity of the national awards Bharat Ratna, Padma Vibhushan, Padma Bhushan and Padma Shri. 2. Right to freedom, Art 19-22. Article 19 guarantees to all citizens the 6 rights. I. Right to freedom of speech and expression. E. Right to assemble peaceably and without arms. E. Right to form associations or unions or cooperative societies. IV. Right to move freely throughout the territory of India. V. Right to reside and settle in any part of the territory of India. Vi. Right to practice any profession. Note: right to acquire, hold and dispose of property was deleted by the 44th Amendment Act of 1978. Filled circle. State can impose reasonable restrictions. X. Sec. 144 can restrain an assembly, meeting if there is a risk of obstruction, annoyance or danger to human life, health or safety. Article 20. Protection in respect of conviction for offenses. Filled circle grants protection against arbitrary and excessive punishment to an accused person, whether citizen or foreigner or legal person. Filled circle. It contains 3 provisions. 30. No ex post facto law. No person shall be, I, convicted of any offense except for violation of a law in force at the time of the commission of the act, nor, e, subjected to a penalty greater than that prescribed by the law in force at the time of the commission of the act. Limitation is imposed only on criminal laws and not on civil laws or tax laws. B. No double jeopardy. No person shall be prosecuted and punished for the same offense more than once. Protection against double jeopardy is available only in proceedings before a court of law or a judicial tribunal, not for administrative courts. Copyright. No self-incrimination. No person accused of any offense shall be compelled to be a witness against himself. Protection against self-incrimination extends to both oral evidence and documentary evidence. However, it does not extend to I. Compulsory production of material objects, E. Compulsion to give thumb impression, specimen signature, blood specimens, and E. Compulsory exhibition of the body. 24. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. It extends only to criminal proceedings and not to civil proceedings. Article 21. Protection of life and personal liberty. Filled circle. No person shall be deprived of his life or personal liberty except according to procedure established by law. Filled circle. Gopalan case, 1950. The Supreme Court has taken a narrow interpretation of Article 21. It held that the protection under Article 21 is available only against arbitrary executive action and not from arbitrary legislative action. Filled circle. Menaka case, 1978, taking a wider interpretation of Article 21. It ruled that the right to life and personal liberty of a person can be deprived by law provided the procedure prescribed by that law is reasonable, fair and just. It has introduced the American expression, due process of law. Filled circle. Right to life also includes right to live with human dignity, not mere survival. Filled circle. UPSC 2019, Art. 21 safeguards right to marry. Filled circle. UPSC 2018, right to privacy is part of right to life and personal liberty is implied in Art. 21. Article 21A, right to education. Added by the 86th Constitutional Amendment Act of 2002. Filled circle. It asks the state to provide free and compulsory education to all children between the ages of 6 to 14 years. Filled circle also included in DPSP Art. 45 and Fundamental Duty Art. 51A. Article 22. Protection against arrest and detention. Parliament and states can currently make laws on preventive detention. Filled circle. Article 22 grants protection to persons under both kinds of detention, namely punitive and preventive. Filled circle. Punitive detention is to punish a person for an offense committed by him after trial and conviction in a court. Filled circle. Preventive detention, on the other hand, means detention of a person without trial and conviction by a court. If a person is arrested after committing a crime, it is called punitive detention. Filled circle. Art. 22 provides following protection against such detention. Right to be informed of the ground of arrest. Filled circle. Right to consult and be defended by a lawyer. Filled circle. Right to be produced before a magistrate within 24 hours of his arrest, excluding the time of journey. Filled circle. Right not to be detained for more than 24 hours without the authority of a magistrate. Filled circle. These are not available to enemy alien or under preventive detention. Filled circle. Safeguards against preventive detention. 25. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. 1. If the detention is for more than 3 months, the matter must be referred to an advisory board in which there shall be a High Court judge. 2. The detention may be continued only where the advisory board considers that there are sufficient grounds for further detention. 3. Grounds of detention must be communicated to the detenu. 4. The detenu must be given an opportunity to make a representation against the order of detention. 3. Right against exploitation, Art. 23 and 24, UPSC pre-2017. Article 23, Prohibition of traffic in human beings and forced labor. Filled circle. This right is available to both citizens and non-citizens. Filled circle. It protects the individual not only against the state but also against private persons. Filled circle. Article 23 also provides for an exception to this provision. It permits the state to impose compulsory service for public purposes, as for example, military service or social service. Article 24, Prohibition of employment of children in factories. Filled circle. Prohibits the employment of children below the age of 14 years in any factory, mine or other hazardous activities. Filled circle. It does not prohibit their employment in any harmless or innocent work. 4. Right to freedom of religion, Art. 25 to 28. Article 25, Freedom of conscience and free profession, practice and propagation of religion. Right of individual. It says that all persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate religion. The implications of these are freedom of conscience, right to profess, right to practice, right to propagate. It does not include a right to convert another person to one's own religion. Article 26, Freedom to manage religious affairs. Right of group. A. Right to establish and maintain institutions for religious and charitable purposes. B. Right to manage its own affairs in matters of religion. C. Right to own and acquire movable and immovable property, and D. Right to administer such property in accordance with law. Article 27, Freedom from taxation for promotion of a religion. No person shall be compelled to pay any taxes for the promotion or maintenance of any particular religion or religious denomination. State should not spend the public money collected by way of tax for the promotion or maintenance of any particular religion. No tax but fee can be levied. 26. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Article 28. Freedom from attending religious instruction. No religious instruction shall be provided in any educational institution wholly maintained out of state funds. However, this provision shall not apply to an educational institution administered by the state but established under any endowment or trust, requiring imparting of religious instruction in such institution. 5. Cultural and educational rights, Art. 29 to 30. Article 29. Protection of interests of minorities. Provides that any section of the citizens residing in any part of India having a distinct language, script or culture of its own, shall have the right to conserve the same. Right to every citizen includes minority as well as majority. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, or language. Article 30. Right of minorities to establish and administer educational institutions. All minorities shall have the right to establish and administer educational institutions of their choice, right only to minority. Compensation amount fixed by state for compulsory acquisition of property of a minority educational institution, 44th AMD. Term minority is not defined in the Constitution. 6. Right to property and saving of certain laws, Article 31. Article 31. Abolition of right to property. The Constitution, 44th Amendment, Act, 1978 omitted Article 19, 1, f, right to acquire, hold and dispose of property, and shifted the provision in Article 31, no person shall be deprived of his property except by law, to another article viz. Article 300a. The effect of this change is that the right to property is no more a fundamental right. Thus the right to property, though still a constitutional right, legal right, is not a fundamental right. If this right is infringed, the aggrieved person cannot access the Supreme Court directly under Art. Exceptions to fundamental rights, Art. 31a. Agriculture reform, industry, commerce, state can acquire personal land, Art. 31b. Acts in 9th Schedule protected being challenged on FR, IR. Coelho case 2007 ruled out blanket immunity. Art. 31c. 1. Laws to implement DPSP 39b and c. Immune by FR, saving of laws giving effect to certain DPSP. 2. No law containing a declaration that it is for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. Kesavananda Bharati case SC declared second provision unconstitutional and void. 7. Right to constitutional remedies, Art.32, filled circle. Art.32 is basic feature of Constitution. Filled circle. Parliament can empower any other court to issue directions, orders, writs. 27. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled circle. The President can suspend the right to move any court for FR during national emergency, Art. 359. Filled circle. Art. 32 is used for only enforcement of fundamental rights. Filled circle. Role of Supreme Court and High Courts regarding constitutional remedies are as follows. Supreme Court, Art. 32, High Court, Art. 226. Filled circle. SC can issue writ for FR under Art.32 and not other rights. Filled circle. Narrow writ jurisdiction. Filled circle SC can issue writ against body throughout country, territorial writ jurisdiction is wider. Filled circle Art. 32 is itself FR, hence SC cannot refuse to exercise writ jurisdiction. Filled circle HC can issue writ for FR as well as other rights. Filled circle wider writ jurisdiction. Filled circle writ against body only confined to that state territory, territorial writ jurisdiction is narrow. Filled circle Art. 226 is discretionary for HC, hence they may refuse. Writs types and scope. Habeas corpus mandamus prohibition certiorari quo warranto. Meaning literally means, to have the body of. Order issued by the court to a person who has detained another person, to produce the body of the latter before it. Literally means, we command. Command issued by the court to a public official asking him to perform his official duties that he has failed or refused to perform. It means, to forbid. Issued by a higher court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction. Prohibition directs inactivity. Preventive. It means, to be certified, or, to be informed. Issued by a higher court to a lower court or tribunal either to transfer a case pending. Certiorari is both preventive as well as curative. It means, by what authority or warrant. Issued by the court to inquire into the legality of claim of a person to a public office. Can be issued against both public authorities as well as private individuals. Any public body, a corporation, an inferior court, a tribunal or government. Issued only against judicial and quasi-judicial authorities. Judicial, quasi-judicial, administrative bodies. Only in case of a substantive public office of a permanent character created by a statute or by the Constitution. 28. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Cannot be issued against. Lawful detention. Contempt of court. Private body, President, CJI. Administrative authorities, legislative bodies, and private individuals. Legislative bodies and private individuals or bodies. It cannot be issued in cases of ministerial office or private office. Armed forces and fundamental rights. Article 33. The Parliament can restrict or abrogate, by law, FRs in the application to. Filled circle the members of armed forces, paramilitary forces, police forces. Intelligence agencies. Filled circle the forces charged with the maintenance of public order. A parliamentary law enacted under Article 33 can also exclude the court-martials, tribunals established under the military law, from the writ jurisdiction of the SC and HC, so far as the enforcement of the fundamental rights are concerned. Article 34. While martial law is in force in any area, the FRs can be restricted. The Supreme Court held that the declaration of martial law does not ipso facto result in the suspension of the writ of habeas corpus. Article 35. Article 35 lays down that the power to make laws, to give effect to certain specified fundamental rights shall vest only in the Parliament and not in the state legislatures. Legal rights, rights outside Part 3. Art. 265, Part 12. No tax shall be levied or collected except by authority of law. Art. 3008, Part 12. No person shall be deprived of his property save by authority of law. Art. 301, Part 13. Trade, commerce and intercourse throughout the territory of India shall be free. Art. 326, Part 15. Adult suffrage, right to vote, UPSC 2017. Directive Principle of State Policy, Part 4, Art. 36-51. Filled circle. It is enumerated in Part 4 of the Constitution from Articles 36 to 51. This idea is borrowed from the Irish Constitution of 1937, which had copied it from the Spanish Constitution. 29. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled circle. The phrase, directive principles of state policy, denotes the ideals that the state should keep in mind while formulating policies and enacting laws. UPSC Pre-2013 DPSP Fundamentals for Governance, UPSC 2020 DPSP is to influence making of laws. Filled circle. The directive principles resemble the instrument of instructions enumerated in the Government of India Act of 1935. Filled circle. They embody the concept of a welfare state, and not that of a police state. UPSC 2020, filled circle. The directive principles are non-justiciable in nature. The directive principles, though non-justiciable in nature, help the courts in examining and determining the constitutional validity of a law. Filled circle. DPSP does not constitute limitations upon legislative or executive functions. However, it guidelines state, UPSC 2017. Filled circle. Art.36. This defines the term state. Filled circle. Art.37. It shall be the duty of the state to include DPSP directives in their policies. Socialistic DPSP, GANDHIAN DPSP, Liberal DPSP. Article 38. I. Create a social order for the promotion of welfare of the people. E. State to minimize inequalities in income, to eliminate inequalities in status, facilities and opportunities. 44th AMD. Article 39. A. Livelihood for all. B. Equitable distribution of resources for common good. C. Prevent concentration of wealth. D. Equal pay to men and women, UPSC 2006. E. Health of workers and children not abused. F. Healthy development of children, 42nd AMD. Article 39A. Equal justice, free legal aid, 42nd AMD. Article 41. Provide right to work, to education and to public assistance. Article 42. Humane condition of work and maternity relief. Article 40. Village panchayats. Article 43. Cottage industries. Art.43b. Cooperative societies, 97th AMD. 2011. Article 46. SC, ST promotion. Article 47. Prohibition of liquor and intoxicating drugs, UPSC. 2007. Article 48. Prohibit slaughter of cows and draft cattle. UPSC Pre-2012 Gandhian DPSP. UPSC Pre-2020 Common Agreement between Gandhism and Marxism is final goal of stateless society. This can be. Article 44. Uniform Civil Code. Article 45. Provision for free and compulsory education for children till the age of 14 years, 86th AMD.2002. Article 48. Organization of agriculture and animal husbandry. Article 48A. Safeguard forest, wildlife, 42nd AMD. Article 49. Preserve monuments, historical interests. Article 50. Separate judiciary from executive, UPSC Pre. 2020. Article 51. Promote international peace and security, UPSC Pre. 2014. UPSC Pre-2013 Economic Justice, Art. 39, B, C, also enshrined in DPSP. 30. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Article 43. Social and cultural opportunity of worker. decent standard of life. Article 43A, participation of workers in industry management, 42nd AMD. UPSC 2017. Article 47, nutrition and public health. Inferred from Gandhian DPSP. UPSC 2015 DPSP spells out socio-economic democracy in country. Outside DPSP. SC, ST Services, Art. 335, Part 16. Instruction in Mother Tongue, Art.350A, Part 17. Development of Hindi, Art.351, Part 17. Conflict between fundamental rights and directive principles. Field Circle Champakam Case 1951, FR greater than DPSP, FR can be amended. Field Circle Golanath Case 1967, FR can not amended for DPSP. Field Circle 25th Const. AMD. Inserted Art. 31C1, for implementation of DPSP 39, B, and C. FR can be amended. 2. Can not be challenged in court. Field Circle Kesavananda Bharati Case, cancelled. Second provision. Field Circle 42nd Const. AMD. DPSP greater than FR. Field Circle Minerva Mills Case 1980, FR superior to DPSP. However, DPSP 39, B, and 9C, greater than FR, 14, 19. Field Circle FR are supreme over DPSP, Parliament can amend further for DPSP. Fundamental Duties, Part 4A, Art.51A, 42nd Const. AMD. 1976. Field Circle FD inspired by USSR Constitution, Japanese Constitution also incorporate FD. Field Circle 1976, Swaran Singh Committee recommended FD. Field Circle 1999, Verma Committee identified legal provisions of FD. Field Circle 42nd Constitutional Amendment Act, 1976, included 10 fundamental duties, 11th FD added by 86th AMD. 2002. Field Circle fundamental duties are confined to citizens only. They are non-justiciable without legal sanction. No legislative process has been provided to enforce FD. UPSC 2017. 1. Respect national flag and anthem. UPSC pre-2011. To vote in public election is not FD. UPSC pre-2012. 31. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. 2. Follow noble ideals. 3. Protect unity and integrity of the nation. 4. Defend country. 5. Promote brotherhood. 6. Preserve rich heritage. 7. Improve, protect environment. 8. Develop scientific temper, humanism. 9. Safeguard public property. 10. Strive towards excellence in all sphere. 11. Child education, 86th Const. AMD. 2002. Amendment of the Constitution. Field Circle Article 368 in Part 20 of the Constitution deals with the powers of Parliament to amend the Constitution and its procedure. Field Circle Indian Constitution is neither flexible nor rigid but a synthesis of both. Field Circle Parliament cannot amend those provisions which form the basic structure of the Constitution. This was ruled by the Supreme Court in the Kesavananda Bharati case, 1973. Field Circle. The procedure for the amendment of the Constitution as laid down in Article 368 is as follows. Field Circle Bill can be initiated in either House of Parliament, UPSC 2013. Field Circle Bill can be initiated either by Minister or private member. Field Circle not require prior permission of President. Filled circle passed by special majority, more than 50% of total membership and 2/3 present and voting. Filled circle federal provisions of bill ratified by half of states by simple majority, UPSC 2013, filled circle 24th Const. AMD. Made obligatory for the President to give assent, President must give assent to Const. AMD. Bill. The Constitution can be amended in 3 ways. Simple majority of Parliament, special majority of Parliament, special majority of the Parliament, and the ratification of half of the state legislatures. Outside the scope of Article 368. 1. Add new states, alter names, areas. 2. Formation of legislative councils. 3. Second schedule. 4. Citizenship. 5. Fifth, sixth schedule. 6. Official languages. The provisions which can be amended by this way includes I. Fundamental rights, E. Directive principles of state policy, and E. All other provisions which are not covered by the first and third categories. Related to the federal structure of the polity. There is no time limit within which the states should give their consent to the bill. 1. Election of the President. 2. Extent of the executive power of the Union and the states. 3. Supreme Court and High Courts. 4. Distribution of legislative. 32. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. 7. Elections to Parliament and States Legislature. Powers between the Union and the States. 5. Goods and Services Tax Council. 6. Any of the lists in the 7th schedule. 7. Representation of states in Parliament. 8. Power of Parliament to amend the Constitution and its procedure, Article 368 itself. Basic structure of the Constitution. Filled circle Shankari Prasad Case 1951, Constitutional validity of First Amendment Act, 1951, which curtailed the right to property, was challenged. SC power to amend Constitution also means amendments to FR. Word, law, in Article 13 includes only ordinary laws and not the Constitutional Amendment Acts. Filled circle Golik Nath Case 1967, the Supreme Court ruled that the fundamental rights are given a transcendental and immutable position, and hence, the Parliament cannot abridge or take away any of these rights. Filled circle 24th AMD. Act 1971, Parliament has the power to abridge or take away any of the fundamental rights under Article 368. Filled circle Kesavananda Bharati Case 1971, overruled Golanath judgment, upheld validity of 24th AMD. Also laid down, doctrine of basic structure. Filled circle 42nd AMD.1976, amended Art.368, no limitations of Parliament and no question shall asked in court. Filled circle Minerva Mills Case 1980, judicial review is basic structure, filled circle basic structure. 1. Supremacy of the Constitution. 2. Sovereign, democratic and republican nature of the Indian polity. 3. Secular character of the Constitution. 4. Separation of powers between the legislature, the executive and the judiciary. UPSC pre-2020, basic structure. Secularism, democracy, fundamental rights. UPSC pre-2018. Rule of law, limitation of power, equality before law, liberty and civil rights. 5. Federal character of the Constitution. 6. Unity and integrity of the nation. 33. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. 7. Welfare state, socio-economic justice. 8. Judicial review. 9. Freedom and dignity of the individual. 10. Parliamentary system. 11. Rule of law. 12. Fundamental rights. Part 2. System of government. Parliamentary system features. Filled circle. The Constitution of India provides for a parliamentary form of government, both at the centre and in the states. Articles 74 and 75 deal with the parliamentary system at the centre and Articles 163 and 164 in the states. Filled circle. The parliamentary system of government is the one in which the executive is responsible to the legislature for its policies and acts. Filled circle. Principle underlying cabinet form of government is mechanism of parliamentary democracy ensuring collective responsibility of government to people, UPSC 2017, filled circle. The parliamentary government is also known as cabinet government or responsible government or Westminster model of government and is prevalent in Britain, Japan, Canada, India among others. Filled circle. The president is the nominal executive, de jure executive or titular executive, while the prime minister is the real executive. Filled circle. The political party which secures majority seats in the Lok Sabha forms the government. Filled circle. The ministers are collectively responsible to the parliament in general and to the Lok Sabha in particular. Article 75. Filled circle. Political homogeneity. Council of ministers belong to the same political party, and hence they share the same political ideology. Filled circle. Ministers are members of both the legislature and the executive. The doctrine of separation of powers is the basis of the American presidential system. The legislative, executive and judicial powers of the government are separated and vested in the three independent organs of the government. Filled circle. Prime Minister plays the leadership role in this system of government. Filled circle. The ministers operate on the principle of secrecy of procedure. Filled circle. The lower house of the parliament, Lok Sabha, can be dissolved by the president on recommendation of the prime minister. Filled circle. Shadow cabinet is a unique institution of the British cabinet system. It is formed by the opposition party to balance the ruling cabinet and to prepare its members for future ministerial office. There is no such institution in India. Federal system. 34. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Federal government. Unitary government. 1. Dual government, that is, national government and regional government. 2. Written constitution. 3. Division of powers between the national and regional government. 4. Supremacy of the Constitution. 5. Rigid Constitution. 6. Independent judiciary. 7. Bicameral legislature. The Constitution of India provides for a federal system of government in the country. Indian federalism is not result of agreements among states. Unlike America, UPSC 2017 term, federation, has nowhere been used in the Constitution. Indian federal system is based on the Canadian model, and not on the American model. 1. Single government, that is, the national government which may create regional governments. 2. Constitution may be written, France, or unwritten, Britain. 3. No division of powers. All powers are vested in the national government. 4. Constitution may be supreme, Japan, or may not be supreme, Britain. 5. Constitution may be rigid, France, or flexible, Britain. 6. Judiciary may be independent or may not be independent. 7. Legislature may be bicameral, Britain, or unicameral, China. Center-state relations. The center-state relations can be studied under 3 heads: legislative relations, administrative relations, financial relations. Legislative relations, administrative relations, financial relations. Filled circle articles 245 to 255 in Part 11. Filled circle. The Parliament can make laws for the whole or any part of the territory of India, state laws limited to state only. Filled circle. Constitution provides for a threefold distribution of legislative subjects between the centre and the states, viz. List I, the Union List, List 2, the State List, and List 3, the Concurrent List, in the 7th Schedule. Filled circle articles 256 to 263 in Part 11. Filled circle. The executive power has been divided between the centre and the states on the lines of the distribution of legislative powers. Filled circle. Executive power of every state is to be exercised in such a way as to ensure compliance with the laws made by the Parliament and any existing law which apply in the state, and b. as not. Filled circle articles 268 to 293 in Part 12. Filled circle. Parliament has exclusive power to levy taxes on subjects enumerated in the Union List and states legislature in State List. Filled circle. Residuary power of taxation remain at Parliament. Filled circle. Present position with respect to the distribution of tax revenues between the centre and the states is as follows. 35. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled circle. 42nd Amendment Act of 1976 transferred 5 subjects to concurrent list from state list, that is, a. Education, b. Forests, c. Weights and measures, d. Protection of wild animals and birds, and e. Administration of justice. Filled circle. The power to make laws with respect to residuary subjects is vested in the Parliament. Filled circle. Constitution empowers the Parliament to make laws on any matter enumerated in the state list under the following 5 extraordinary circumstances. 1. When Rajya Sabha passes a resolution supported by 2/3 members present. 2. During a national emergency the laws become inoperative on 3. The expiration of 6 months after the emergency has ceased to operate. 4. When the legislatures of 2 or more states pass resolutions requesting the Parliament to enact laws on a matter in the state list, then the Parliament can make laws. 5. The Parliament can make laws on any matter in the state list for implementing the international treaties, agreements. 6. When the President's rule is imposed in a state, the Parliament becomes to impede or prejudice the exercise of executive power of the centre in the state. Filled circle. Article 365 says that where any state has failed to comply with, or to give effect to, any directions given by the centre, President's rule can be imposed in the state under Article 356. Filled circle. Under Art. 356 the power of legislature of that state is exercisable by or under authority of Parliament, UPSC 2018. Filled circle. Centres directions to the states. 1. Maintenance of means of communication. 2. Protection of the railways. 3. Adequate facilities for instruction in the mother tongue at the primary stage of education. 4. Execution of the specified schemes for the welfare of the scheduled tribes. Filled circle. The President may, with the consent of the state government, entrust to that government any of the executive functions of the centre. Field Circle All India Services. Article 312 of the Constitution authorizes the Parliament to create new All India Services on the basis of a Rajya Sabha resolution to that effect. Field Circle Integrated Judicial System. Single system of courts enforces both the central laws as well as the state laws. The judges a. Taxes levied by the centre but collected and appropriated by the states. Article 268 includes the stamp duties on bills of exchange, checks, promissory notes. b. Taxes levied and collected by the centre but assigned to the states. Article 269 Sales of goods in interstate trade or commerce. c. Levy and collection of goods and services tax in course of interstate trade or commerce. Article 269a. d. Taxes levied and collected by the centre but distributed between the centre and the states. Article 270. e. Surcharge on certain taxes and duties for purposes of the centre. Article 271. Field Circle grants in aid to the states. Statutory grants. Article 275 empowers the Parliament to make grants to the states which are in need of financial assistance and not to every state. Discretionary grants. Article 282 empowers both the centre and the states to make any grants for any public purpose. Centre is under no obligation to give these grants and the matter lies within its discretion. 36. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Empowered to make laws with respect to any matter in the state list in relation to that state. A law made so by the Parliament continues to be operative even after the President's rule. Of a state high court are appointed by the President in consultation with the Chief Justice of India and the Governor of the state. Field Circle 101st Amendment Act of 2016 provided for the establishment of a Goods and Services Tax Council or the GST Council. Article 279a empowered the President to constitute a GST Council by an order. Various Commission reports on Centre-State relations. Administrative Reform Commission 1966. Field Circle under chairmanship of Moraji Desai, followed by K. Hanumanthaya. Field Circle Recommendation 1, establish Interstate Council. 2. Appointment of governors, non-partisan. 3. Maximum powers to state, more financial resources to states. RAJAMANNAR. Committee 1969 Field Circle 1969, TN Government, appointed committee identified centralization trend in Centre-State relation, hence recommended 1. Finance Commission to permanent body. 2. Omit President's rule. 3. Abolish all India services. 4. Residuary powers to state. SARKARIA. Commission 1983 Field Circle Permanent Interstate Council. Field Circle Extreme, rare use of President's rule. Field Circle strengthen all India services. Field Circle Armed Forces to deploy without consent of states. Field Circle 3-language formula. Field Circle Center to consult state before laws on concurrent list. Field Circle other residuary powers vested in concurrent list. Field Circle appointment of governors. He should be outside of state, not be eligible for any office of profit, can appoint for second term. UPSC pre-2018. PUNCHHI. Commission 2007 took help of Sarkaria.com. Report and second arc. Cooperative federalism is key for unity. Field Circle selection of governors on the basis of Sarkaria.com. Recommendation. Field Circle Governor impeachment procedure same as President. Field Circle Governor not to be Chancellor of University. Field Circle create new All India services. Field Circle setting up Interstate Trade and Commerce Commission. 37. Telegram. https://t.me/IAS Network website, www.IAS Network Contact, 9,779,726,117. Interstate Relations. Field Circle Article 262 of the Constitution provides for the adjudication of interstate water disputes. It makes two provisions. I. Parliament may by law provide for the adjudication of any dispute. E. Parliament may also provide that neither the Supreme Court nor any other court is to exercise jurisdiction. Field Circle Interstate Water Dispute Tribunals set up so far. Name set up in states involved: Krishna water disputes. Tribunal I 1969 Maharashtra, Karnataka and Andhra Pradesh. Godavari water disputes. Tribunal 1969 Maharashtra, Karnataka, Andhra Pradesh, Madhya Pradesh and Odisha. Narmada water disputes. Tribunal 1969 Rajasthan, Gujarat, Madhya Pradesh. And Maharashtra Disputes Tribunal 1986 Punjab, Haryana and Rajasthan. Ravi and Bees water. Kaveri water disputes. Tribunal 1990 Karnataka, Kerala, Tamil Nadu and Puducherry. Krishna water disputes. Tribunal 2 2004 Maharashtra, Karnataka and Andhra Pradesh. Vansadhara water disputes. Tribunal 2010 Odisha and Andhra Pradesh. Mahadayi water disputes. Tribunal 2010 Goa, Karnataka and Maharashtra. Mahanadi water disputes. Tribunal 2018 Odisha and Chhattisgarh. Interstate Councils. Article 263 for establishment of an interstate council to effect coordination between the states and between center and states. Field Circle President can establish ISC and defines nature and duties. Field Circle Council can advise SC on legal controversies between states as per jurisdiction of SC by Art. 131. Field Circle President has established the following councils: Central Council of Health and Family Welfare, Central Council of Local Government 3, 4 regional councils for sales tax for the northern, eastern, western and southern zones. Field Circle by recommendations of Sarkaria Commission, the Janata Dal government headed by V. P. Singh established the Interstate Council in 1990. 38. Telegram. https://t.me/IAS Network website, www.IAS. Network Contact, 9,779,726,117. Field Circle. It consists of the following members: I. Prime Minister as the Chairman. E. Chief Ministers of all the states. E. Chief Ministers of Union Territories having legislative assemblies. IV. Administrators of Union Territories not having legislative assemblies. V. Governors of states under President's rule. Vi. 6 Central Cabinet Ministers, including the Home Minister, to be nominated by the Prime Minister. Field Circle Standing Committee of ISC, Home Minister plus 5 Cabinet Ministers plus 9 CM of states. Field Circle ISC Secretariat, headed by Secretary of Government, also works as Secretary to Zonal Council. Interstate Trade and Commerce, Art. 301 to 307, Part 12 Zonal Councils, Statutory Body. Field Circle Zonal Councils are the statutory, and not the constitutional, bodies. Field Circle. They are established by an Act of the Parliament, that is, the States Reorganization Act of 1956. Field Circle 5 zones: Northern, Central, Eastern, Western and Southern. Field Circle members: A. Home Minister * of Central Government Chairman. B. Chief Ministers of all the states in the zone. C. 2 other ministers from each state in the zone. D. Administrator of each Union Territory in the zone. Field Circle. Each Chief Minister acts as a Vice Chairman of the Council by rotation, holding office for a period of 1 year at a time. Field Circle Northeastern Council. In addition to the above zonal councils, a Northeastern Council was created by a separate Act of Parliament, the Northeastern Council Act of 1971. Its members include Assam, Manipur, Mizoram, Arunachal Pradesh, Nagaland, Meghalaya, Tripura and Sikkim. Emergency provisions. National emergency, Art. 352, President's Rule, Art. 356, Financial emergency, Art. 360, Grounds of Declaration, Filled Circle President to proclaim financial emergency, if he, satisfied, that situation arrest. Grounds of Declaration, Filled Circle Art. 352, External Aggression or Armed Rebellion, 44th AMD, Filled Circle 42nd AMD. 1976 President can limit operation of national emergency to particular area. Filled Circle National Emergency 1975. Due to internal disturbance Filled Circle the President can proclaim only after receiving a written recommendation from Cabinet, 44th AMD. Filled Circle Proclamation of National Emergency brought under judicial review, 44th AMD. Grounds of Declaration. Filled Circle it is also known as State Emergency. Filled Circle Art. 355 Duty on Centre to ensure state government is working in accordance to Constitution. Filled Circle Art. 356 Duty on Centre to take over state government in case of Constitution failure in state. Filled Circle 2 Grounds to proclaim President's Rule. 1. Art. 356 President to proclaim, if satisfied action without Governor's report. Approval. Filled Circle must approved by both Houses of Parliament within 2 months. Filled Circle resolution of approval can be passed by simple majority. Filled Circle continues indefinitely till it revoked. Filled Circle no maximum period specified. 39. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Minerva Mills case. Approval. Filled Circle must be approved by both Houses within 1 month from date of issue, 44th AMD. Filled Circle if approved continues for 6 months, can be extended to infinite with the approval for every 6 months, periodic parliamentary approval 44th AMD. Filled Circle approval for continuous by either of Houses by special majority, 44th AMD. Revocation. Filled Circle President must revoke if LOKSABHA, 1/10 of total members of Lok Sabha give written notice to Speaker, 44th AMD. Filled Circle revocation by simple majority. Effects on Centre-State relations. A. Executive Centre extends its executive power to states, give directions to states on any matter, state government is not suspended but complete control by Centre. B. Legislative Parliament make laws on state list however legislative power of state is not suspended, laws of Parliament inoperative 6 months after emergency ceased, President can issue ordinance on state subjects. 2. Art. 365 State fails to comply with directions of Centre. Approval. Filled Circle must be approved by both Houses within 2 months from date of issue. Filled Circle if approved, it will continue for 6 months, can be extended for max 3 years with approval of Parliament. Filled Circle continuation, either House, by simple majority. Filled Circle condition for continuance. 1. National emergency in whole country. 2. Election Commission to certify no general elections due to difficulties. Revocation. Filled Circle revoked by President any time, no parliamentary approval needed. Effects on State Assembly. Filled Circle President dismisses State Council of Ministers. Filled Circle Governor on behalf of Centre carry administration with help of Chief Secretary, Authority of Parliament, and advisor appointed by President, UPSC 2018. Filled Circle President either suspend, dissolve State Assemble. Filled Circle removal of Council of Ministers of SLA. Filled circle no parliamentary approval needed for continuation. Revocation. Filled circle financial emergencies can be revoked by the President any time without parliamentary approval. Effects. Center extends executive authority. Filled circle directing states to observe financial propriety. Filled circle direction to President. A. Reduction of salaries and allowances. B. Reservation of all money, other financial bills for consideration of presidents. C. Reduction of salaries and allowances for union and state and judges of SC and HC. UPSC 2007 Proclamation of Financial Emergency Art. 360. 40. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. C. Financial President can modify, reduce, cancel, distribution of revenues of states such order, President has to laid before Parliament. Effect on Loksava and State Assembly. Loksava may extend for 1 year at a time. Extension cannot continue beyond 6 months after emergency ceased to operate. Parliament may extend tenure of State Assembly. Effects on fundamental rights. Art. 358 and Art. 359 Effects on FR during national emergency. Filled circle Art. 358 automatically suspends 6 rights of FR 19 only when national emergency on external aggression. FR 19 suspends for entire duration of emergency and extended to entire country. Filled circle Art. 359 suspension of other FR except FR 20 and 21. Suspends FR at both cases, armed rebellion or external. President may specify duration and the suspension of FR may apply to entire country or any part of country. Filled circle 44 THAMD. Automatic suspension of FR 19 only on external aggression and Art. 359 President suspend right to seek remedy except for FR 20 and 21. State Legis. Assembly not dissolves automatically, UPSC 2017. Filled circle 44th Constitutional AMD 1978. Satisfaction of President. This provision is brought under judicial review. Comparative study of Part 3 Central Government and Part 6 State Government. 41. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. President, Art. 52 to 78, Part 5, Governor, Art. 153-167, Part 6. Election, by members of Electoral College consisting 1. Elected members of both LS plus RS. 2. Elected members of State Legislature. 3. Elected member of UT, Delhi plus Puducherry. Vote of MLA equals total pop. Of State, number. Of elected members x 1000, vote of MP equals total value of votes of MLA, total no. Of elected members of LS plus RS, value of vote of each MLA varies from state to state, UPSC 2018. Filled circle election by proportional representation by means of single transferable vote and voting secret ballot. Filled circle all disputes with elections of President resolved by Supreme Court. Qualification. Filled circle 35 years above age, qualified for member of LS. Filled circle oath administered by CJI. Condition of office. I. Not member of either house. E. No office of profit. E. Immune from criminal proceeding, even if personal. IV. 2 months notice in civil proceedings during term. Term. 5 years, resign addressing to Vice President, eligible for reappointment any no. Of term. Impeachment. Filled circle impeachment for violation of Constitution. Filled circle initiated by either house. Filled circle signed by 1/4 member and 14 days notice to President. Filled circle resolution passed by special majority by both houses. Filled circle, elected plus nominated members of LS plus RS. Participate. Filled circle no member. From state legislature nut. Filled circle art. 153 to 167, state executives. Filled circle governor, chief executive head, nominal head of state. Filled circle 7th const. AMD.1956, same person as governor. Of two or more state, UPSC 2013. Filled circle appointment, governor appointed by president by warrant under his seal. Filled circle he is central nominee but independent. Constitutional office. Filled circle Canadian model of appointment of governor. Qualification. Filled circle citizen of India, completed 35 years. Filled circle governor belong to other state is recommendation of Sarkaria Commission, not constitutional provision. Filled circle oath admin. By CJ of HC. Condition of office. I, not member of either house. E, no office of profit. E, immune from criminal proceeding, even if personal, no criminal proceeding during term, UPSC. 2018. IV, 2 months notice in civil proceedings during term. Art. 158 The emoluments and allowances of the Governor of State shall not be diminished during his term of office, UPSC 2018. Term. 5 years, subjected to pleasure of President, pleasure, not under judicial review. Filled circle governor has no security of tenure. Filled circle no ground specified for removal of governor. Filled circle transfer of governors by president, UPSC 2013. Filled circle reappointment in same state is possible. Filled circle chief justice of HC may be appointed temporarily if office vacant. 42. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Powers of President. 1. Executive. Executive power of Union of India is vested in President. UPSC 2015. Make rules for transaction of business of Union Government. Appoints PM, Com, Attorney General, CAG, Governors, etc. Declare any area scheduled area. 2. Legislative. Summon, prorogue, dissolve LS. Appoint speakers and department. Speakers when office vacant. Nominates 12 personalities to RS. Decides disqualification of members with election commission. Issue ordinance. 3. Financial. Money bill prior recommendation. Union budget after President summon. Constitute Finance Commission. 4. Judicial. Appoints CJI, judges of SC and HC. Seek advice from SC. Grant pardon. Commute punishment. 5. Veto power. President has 3 alternatives for bills: assent, withhold, return. President of India enjoys 3 veto power, no qualified veto, i.e. overridden by legislature with higher majority. Filled circle absolute veto, to withhold his assent to bill then bill ends, it is available for private members' bill and when cabinet resigns. Filled circle suspensive veto, when he returns bill for reconsideration, no suspensive veto available for money bill. Filled circle pocket veto, simply keeping bill pending for indefinite time, no action, no pocket veto available for constitutional AMD. Bill. Indian pocket veto greater than wider than American. Filled circle president's veto power over state bills. Art. 200. Governor has 4 options: assent, withhold, return and reserve for president. Art. 201. If bill is reserved for president's consideration, he has 3 options: assent. Powers of governor. 1. Executive. Appoints tribal welfare minister, appoints CM, advocate general, state election commissioner, acts as chancellor of university in state. 2. Legislative. Summon, prorogue, dissolve State Legislative Assembly, nominates -1/6 member in Council, give assent or withhold assent, return bills and also can reserve bills for consideration of President, issue ordinance. 3. Financial. Money bills only with prior recommendations of Governor, constitutes State Finance Commission every 5 years. 4. Judicial. He consulted by President while appointments of judges of H.C., pardoning power except death sentence. 5. Veto power. For ordinary laws Governor has 4 alternatives: assent, withhold, return and reserve bill. Regarding money bills, Governor has 3 alternatives: it cannot return bill for reconsideration. If money bill reserved by Governor for President, then President has 2 options: assent the bill or withhold assent. President cannot return money bill. Ordinance making power. Art. .213. 43. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Withhold assent, direct Governor to return bill, President is not bound to give assent to bill. Ordinance making power, Art. 123. President to promulgate ordinance during recess of Parliament. 1. Promulgate only when both, LS plus RS, not in session or either of House not in session. 2. Only when he is satisfied to take action, 44th AMD, satisfaction is under judicial review. 3. When Parliament reassembles both houses must approve to become Act, expiry 6 weeks, max. Life 6 months 6 weeks. 4. Can issue ordinance only on advice of Council of Ministers. 5. Ordinance cannot be issued to amend Constitution. 6. Ordinance making power of President is coextensive with Parliament but not parallel. Pardoning power of President, Art. .72. Filled circle. It is an executive power, independent of judiciary. Filled circle pardon, completely absolves conviction. Filled circle commutation, substitution to lighter punishment. Filled circle remission, reducing period without changing character of punishment. Filled circle respite, lesser sentence than original due to special facts: pregnancy, disability, etc. Filled circle reprieve, stay on execution for temporary period. Discretionary power, situational. 1. Appointment of PM and Com when no majority in Lok Sabha or when PM dies in office. 2. Dismiss Com if no confidence motion approved. 1. Promulgate ordinance when both or either of House not in session in case of bicameral. 2. Only when he is satisfied to take action, 44th AMD, satisfaction is under judicial review. 3. Can issue ordinance only on advice of Council of Ministers. 4. Ordinance making power of President is coextensive with Parliament but not parallel. 5. Ordinance making power of Governor is not discretionary power. President can instruct Governor on ordinance making. Pardoning power of Governor. Filled circle pardon, commute, reprieve, respite, suspend. Convicted of any offense against state laws. Filled circle no pardon for death sentence, but Governor can suspend, remit, commute death sentence. Discretionary power in Constitution for Governor, UPSC 2014. 1. Reservation of bills for President's consideration. 2. Recommend President's rule. 3. Administration of adjoining UT. 4. Seeking information from Chief Minister, CM, regarding administrative and legislative policies. Additional discretion. Establishment of separate development board. MH, GJ, Assam, Nagaland, Manipur, Sikkim, Arunachal Pradesh, Karnataka. 44. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. 3. Dissolve Lok Sabha if COM lost majority. Important facts. 1. Dr. Rajendra Prasad twice president. 2. Sanjeevan Reddy unopposed in 1977. 3. Zakir Hussain died in office 1969. 4. V. Giri acting president. Vice president. Filled circle second highest office, modeled on American vice president. Filled circle VP is not directly elected by people but elected by members of Electoral College both houses. 1. Consists both elected plus nominated members of both houses. 2. Not include members of state legislature assembly and UT. Filled circle election by proportional representation by single transferable vote. Filled circle qualification, 35 years age completed, qualified for member of RS, no office of profit. Filled circle term 5 years, can be removed from office by resolution of Rajya Sabha passed by special majority and agreed by LOKSABHA 14 days notice given. No grounds for removal mentioned. Filled circle VP is ex officio chairman of RS, his power similar to speaker. Filled circle VP acts as president when there is vacancy in president's office due to death, removal. Filled circle DRS Radhakrishna elected as VP for 2 terms, Krishnakant first VP to die serving office. Prime Minister and Chief Minister. Prime Minister, Chief Minister. Filled circle constitution not specified procedure for selection of PM. Filled circle Art. 75 Prime Minister shall be appointed by President. President has to appoint leader of majority party in Lok Sabha. Filled circle when no majority, President can apply his discretion. President Neelam Reddy appointed Charan Singh. Filled circle President may first appoint PM then ask to prove his majority in Lok Sabha. Filled circle constitution not specified procedure for selection of CM. Filled circle Art. 164 Chief Minister shall be appointed by Governor. Governor has to appoint the leader of the majority party in state legi. Assembly, SLA, filled circle when no majority, Governor can apply his discretion. 45. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled circle 1997, SC held that person not member of either house can be appointed as PM for 6 months within which he should become member of any house. Filled circle term, not fixed, and hold office during pleasure of President. Filled circle Art. 78, PM acts as channel of communication between President and Council of Ministers. Filled circle Governor may first appoint CM then ask to prove his majority in SLA. Filled circle person not member of either house can be appointed as CM for 6 months within which he should become member of any house. Filled circle term, not fixed, and hold office during pleasure of Governor. Council of Ministers. Filled circle Art. 74 Com to aid and advise the President. President shall act according to advice tendered. Advice tendered by ministers shall not be inquired in court. Filled circle Art. 163 Counsel with CM aid and advice Governor except in his discretion. Filled circle Art. 75 Com on advice of PM, appointed by President, total number of Com plus PM shall not exceed 15% of total members of LS, 91st AMD.2003, Com holds office during pleasure of President, UPSC 2013, 2007. Filled circle Art. 75 when LS passes a no confidence motion against Council of Ministers, all ministers, including those ministers who are member of RS have to resign, collective responsibility. Filled circle Art. 164 Other ministers shall be appointed on advice of CM, by Governor. Filled circle if members of either house disqualified on the grounds of defection, also disqualified to be Appointed as ministers. Filled circle satisfaction of President equals satisfaction of Council of Ministers. Filled circle Council of Minister is constitutional body whereas Cabinet Ministers only mentioned in Art. 352. Of national emergency originally it was not mentioned. Filled circle Cabinet Ministers are actual center of power, they supervise Cabinet Committees extra constitutional body provided by rules of business. Filled circle set up by Prime Minister as per requirement. Filled circle Cabinet Committee chaired by PM appointment Economic Affair Political Affair Security Investment and Growth Skill Development Filled circle Parliamentary Affair Committee is chaired by Home Minister. Filled circle Cabinet Secretariat, preparation of agenda of Cabinet meetings, secretarial assistance to Cabinet committees, UPSC 2014. Parliament, Part 5, Art. 79 to 122. Filled circle Parliament consists of President plus Lok Sabha plus Rajya Sabha, UPSC 2012. Filled circle Indian parliamentary model is based on British Westminster model. Composition of Rajya Sabha, composition of Lok Sabha. Filled circle maximum strength equals 250, 238 elected indirectly, and 12 nominated by President. Filled circle maximum strength equals 552, 530 states plus 20 UT. 46. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled circle, 4th schedule allocation of seats in Rajya Sabha to states and UT. Filled circle RS members. Elected members of State Legislative Assembly are represented in RS by system of proportional representation, seats to states based on population. Filled circle representatives of UTs in RS indirectly elected by member of Electoral College with system of proportional representation. Filled circle, only 2 UTs Delhi and Puducherry have representation in RS, UPSC 2012. Filled circle president nominates 12 members to RS from different fields. Filled circle 2 members are nominated from the Anglo-Indian community if not represented adequately, 95th AMD. Filled circle members to Lok Sabha from states and UTs chosen by direction elections. Term. Rajya Sabha is a permanent body, no dissolution, however 1/3 members retire every 2 years. Constitution not fixed term for RS. Representation of People Act 1951 mentioned 6 years term for RS. Lok Sabha normal term is 5 years, can be extended by 1 year at a time of national emergency. Qualification of members, disqualification of members. Constitution mentioned. Filled circle should be citizen of India. Filled circle make oath to Election Commission. Filled circle for RS not less than 30 years and for LS not less than 25 years. Representation of People Act 1951 mentioned. Filled circle person should be registered as an elector. Filled circle for RS it is not necessary that person should be elector in particular state, UPSC 2017. For election to Lok Sabha a nomination paper can be filled by any citizen of India whose name appears in the electoral roll of a constituency. Constitution mentioned. Filled circle if he hold office of profit. Filled circle if not citizen of India. Filled circle if disqualified by law made by Parliament. RPA, 1951, mentioned. Filled circle not guilty of election offence, corrupt practice. Filled circle no imprisoned for 2 or more YRS. Filled circle not dismissed from government. Services. Filled circle president's decision is final on disqualification and president can consult with Election Commission. Disqualification on grounds of defection. Filled circle defection under 10th schedule. Filled circle question of disqualification under 10th schedule is decided by chairperson of that house, i.e. chairman in RS and speaker in LS. however their decision is subjected to judicial review. Speaker in Loksabha. Deputy Speaker in Lok Sabha. Filled Circle Speaker is elected by Lok Sabha among its member. Filled Circle Deputy Speaker is elected by Lok Sabha among its member itself. Filled Circle Deputy Speaker is not subordinate to Speaker. 47. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled Circle. He is guardian of power and privileges of members. Filled Circle. His decision in all parliamentary matter is final. Filled Circle adjourns House or suspend if no quorum maintained. Filled Circle exercise casting vote in case of tie, can not vote in first instance. Filled Circle presides over joint sitting. Filled Circle decides bill is money bill or ordinary. Filled Circle decides disqualification of members on the grounds of defection in 10th Scald. Filled Circle. He is chairman of Business Advisory Committee, Rules Committee, General Purpose Committee. Filled Circle Speaker can removed only by resolution passed by an absolute majority. 14 days notice given. Filled Circle Speaker is at higher rank than all cabinet ministers. Filled Circle in India. Speaker does not resign from party. In Britain Speaker is non-party person. Filled Circle whenever he presides over House cannot vote in first instance. Filled Circle not by constitutional provision but parliamentary convention. Generally the Speaker is from the ruling party and department. Speaker is from opposition party, UPSC 2017. Filled Circle. GOI 1919 provision for Speaker and department. Speaker. Panel of Chairperson in Loksabha. Filled Circle rule of Lok Sabha. Speaker nominates panel of 10 members. Any one of them can preside if office of Speaker and Deputy Speaker is absent. Speaker pro tem. Filled Circle President appoints a member of Lok Sabha as Speaker pro tem, temporary. Chairman of Rajya Sabha. Deputy Chairman of Rajya Sabha. Filled Circle Vice President of India is ex officio. Chairman of RS. Filled Circle Chairman can be removed from office only if he removed from office of Vice President. Filled Circle Chairman is not member House unlike Speaker, UPSC 2013. Filled Circle elected by Rajya Sabha among its members. Filled Circle removal by absolute majority. Filled Circle Department Chairman is not subordinate to Chairman. Leader of House. Leader of Opposition. Filled Circle under rules of Lok Sabha, PM, is Leader of House or Minister nominated by PM. Filled Circle in Rajya Sabha, PM nominates ministers as Leader of House. Filled Circle for the first time Leader of Opposition. Recognized in 1969, UPSC 2018. Filled Circle statutory recognition in 1977 because it is mentioned in Salary Act. Filled Circle not less than 1/10 seats of total seats required for recognition as opposition. Filled Circle Leader of Opposition is equivalent to Cabinet Minister. WHIP not mentioned in Constitution. Not in rules, nowhere mentioned. 48. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Based on parliamentary convention, every political party has own whip. Sessions of Parliament. Summoning. President summons each House time to time. Session duration between first sitting and prorogation. Recess duration between prorogation and reassembly. Adjournment. Each meeting of day consists 2 sitting terminated by adjournment. It suspends work for specific time. Adjournment sign. Die terminating sitting for indefinite period without naming day of reassembly. Power of adjournment and adjournment signed by les with presiding officer PROROGATION. Presiding officer declares House adjourned signed by when business of session completed. Then President issue prorogation dissolution only ls subjected to dissolution position of bills with respect to lapsing of bills. UPSC 2016, filled circle bill passed by both houses but returned by President not lapse. Filled circle bill passed by both houses but pending assent not lapse. Filled circle bill pending in RS, not passed by LS not lapse. Filled circle bill pending in LS lapses, wherever originated. Filled circle bill pending in RS but passed by LS lapses. Other terms related to the parliamentary functioning. Filled circle quorum. It is the minimum number of members whose presence is essential to transact the business of the House. Filled circle question hour. The day's business normally begins with the question hour, during which questions asked by the members are answered by the minister. The different types of questions are: starred question. It is one for which an oral answer is required to be given by the minister on the floor of the House. Supplementary questions may be asked based on the minister's reply. Unstarred question. It is one for which the minister lays on the table a written answer. A 15-day notice has to be given to ask such questions, and no supplementary questions can be asked with regard to such questions. Short notice question. This type of question which can be asked by members on matters of public importance of an urgent nature. It is for the Speaker to decide whether the matter is of urgent nature or not. The member has also to state reasons for asking the question while serving notice. Filled circle 0 hour. This period follows the question hour, and it normally begins at noon. Usually, the members use this period to raise various issues for discussion. 0 hour not mentioned in rules of procedure. It is Indian innovation of parliamentary procedure. Filled circle motions. To express opinions on various issues by ministers, private members. 3 principal categories of motions. 49. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. 1. Substantive motion matter like impeachment of President, removal of Chief Election Commissioner. 2. Substitute motion moved in substitute to original motion and passes alternative to it. 3. Subsidiary motion reference to original motion. Filled circle closure motion to cut short debate on provisions of bills. Kangaroo closure only important clause taken for debate and voting. Other clauses skipped. Guillotine closure undiscussed clauses of bill put to vote along discussed clauses due to matter of time. Filled circle privilege motion concerned with breach of parliamentary privileges by minister by withholding facts or giving wrong facts, used against minister. Filled circle calling attention motion to call attention of minister on matter of urgent public importance. It is Indian innovation to parliamentary procedure. It is mentioned in rules of procedure. Filled circle adjourned motion to draw attention of House to definite matter of urgent public importance. It is an extraordinary device as interrupts normal business of House. It is used only in Lok Sabha. RS is not permitted to use this motion. UPSC 2012. Filled circle no confidence motion. This motion is not mentioned in Constitution. In Lok Sabha, removal of minister by passing this motion. Motion needs support of 50 members to be admitted. There is no need to state reasons for adoption of this motion. This motion can be moved against entire council. If passed in LS, then council of minister must resign. UPSC 2014. Filled circle censure motion. There is need to state the reason for adoption of this motion. Can be moved against individual or group of ministers. It means censuring council for specific policies. If passed in LS, then entire council of ministers need not to resign from office. Filled circle motion of thanks. President addresses motion of thanks in the first session after every general election and first session of every fiscal year. It is discussed in both houses. Motion outlines government policies. Motion must be passed, otherwise it amounts defeat of government. Filled circle point of order. Members can raise point of order when proceedings of House do not follow normal rule of procedure. Usually Leader of Opposition raise this device. It is an extraordinary device. Filled circle special mention. A matter which cannot be raised during any other rules of business, can be raised in special mention in Rajya Sabha. It is equivalent to notice device of Lok Sabha. Filled circle resolutions. Private member resolution discussed on alternative Fridays. Government resolution moved by ministers from Monday to Thursday. All resolution came in category of substantive motion. All motions need not to be voted upon, but all resolutions required to voted upon. Filled circle UPSC 2017. Parliament exercises control over COM through adjournment motion, question hour, supplementary questions and other parliamentary devices. Legislative procedure in Parliament. The bills introduced in the Parliament can also be classified into 4 categories. 1. Ordinary bills, which are concerned with any matter other than financial subjects. 2. Money bills, which are concerned with financial matters like taxation, public expenditure, etc. 3. Financial bills, which are also concerned with financial matters, but are different from money bills. 50. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. 4. Constitution amendment bills, which are concerned with the amendment of the provisions of the Constitution. Public bill. Private bill. 1. It is introduced in the Parliament by a minister. 2. It reflects the policies of the government, ruling party. 3. It has a greater chance to be approved by the Parliament. 4. Its rejection by the House amounts to the expression of want of parliamentary confidence in the government and may lead to its resignation. 5. Its introduction in the House requires 7 days' notice. 6. It is drafted by the concerned department in consultation with the law department. 1. It is introduced by any member of Parliament other than a minister. 2. It reflects the stand of the opposition party on public matters. 3. It has lesser chance to be approved by the Parliament. 4. Its rejection by the House has no implication on the parliamentary confidence in the government or its resignation. 5. Its introduction in the House requires 1 month's notice. 6. Its drafting is the responsibility of the member concerned. Only 14 private members' bills passed since independence. UPSC 2017. Money bills, Art.110, Financial bills, Art.117, Financial bills, I. Filled circle. Art.110 of the Constitution deals with the definition of money bills. Filled circle. It states that a bill is deemed to be a money bill if it contains, only, provisions dealing with all or any of the following matters. 1. The imposition, abolition, remission, alteration or regulation of any tax. 2. The regulation of the borrowing of money by the Union government. 3. The custody of the Consolidated Fund of India or the Contingency Fund of India. 4. Regulation of borrowing of money or giving of any guarantee by GOI. UPSC 2018. Filled circle. If any question arises whether a bill is a money bill or not, the decision of the Speaker of the Lok Sabha is final. His decision in this regard cannot be questioned in any court of law. Filled circle. A money bill can only be introduced in the Lok Sabha and that too on the recommendation of the President. Filled circle can be introduced only by a minister. Filled circle. The Rajya Sabha has restricted powers with regard to a money bill. It cannot reject or amend a money bill. It can only make the recommendations. It must return. Filled circle. Bill that contains not only any or all the matters mentioned in Article 110, but also other matters of general legislation. Filled circle. A financial bill, I, is similar to a money bill, both of them can be introduced only in the Lok Sabha and not in the Rajya Sabha, and b. Both of them can be introduced only on the recommendation of the President. Filled circle. It can be either rejected or amended by the Rajya Sabha, except that an amendment other than for reduction or abolition of a tax cannot be moved in either house without the recommendation of the President. Filled circle. In case of a disagreement between the two houses over such a bill, the President can summon a joint sitting of the two houses to resolve the deadlock. Filled circle. President can give assent, withhold it or return for reconsideration. Financial bills. 2. Filled circle. A financial bill, 2, contains provisions involving expenditure from the Consolidated Fund of India, but does not include any of the matters mentioned in Article 110. 51. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. The bill to the Lok Sabha within 14 days, whether with or without recommendations. Filled circle. Lok Sabha may accept or reject amendments recommended by RS in the Money Bill, UPSC 2013. Filled circle. When a money bill is presented to the President, he may either give his assent to the bill or withhold his assent to the bill but cannot return the bill for reconsideration of the Houses. Ordinary bill. Filled circle can be introduced either in the Lok Sabha or the Rajya Sabha. Filled circle can be introduced either by a minister or by a private member. Filled circle introduced without the recommendation of the President. Filled circle can be amended or rejected by the Rajya Sabha. Filled circle does not require the certification of the Speaker. Filled circle. In case of a deadlock due to disagreement between the two houses, a joint sitting of both the houses can be summoned by the President to resolve the deadlock. Filled circle. Its defeat in the Lok Sabha may lead to the resignation of the government, if it is introduced by a minister. Filled circle. It is governed by the same legislative procedure which is applicable to an ordinary bill. Filled circle. Financial bill, 2, can be introduced in either House of Parliament and recommendation of the President is not necessary for its introduction. Filled circle. The President can summon a joint sitting of the two houses to resolve the deadlock. Filled circle. President can give assent, withhold it or return for reconsideration. Joint sitting of two houses. An extraordinary machinery provided by the Constitution to resolve a deadlock between the two houses over the passage of a bill. The President can summon both the houses to meet in a joint sitting for the purpose of deliberating and voting on the bill. It must be noted here that the provision of joint sitting is applicable to ordinary bills or financial bills only and not to money bills or constitutional amendment bills. The Speaker of Lok Sabha presides over a joint sitting of the two houses and the Deputy Speaker, in his absence. If the Deputy Speaker is also absent from a joint sitting, the Deputy Chairman of Rajya Sabha presides. Provision regarding the joint sitting of the two houses has been invoked only thrice. Bill referred to joint sitting is passed by a simple majority of members present and voting, UPSC 2015. Budget in Parliament. 52. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled circle. The Constitution refers to the budget as the annual financial statement. In other words, the term budget has nowhere been used in the Constitution. Filled circle. The railway budget was separated from the general budget in 1924 on the recommendations of the Ackworth Committee Report, 1921. Filled circle. In 2017, the central government merged the railway budget into the general budget. Filled circle. The President shall in respect of every financial year cause to be laid before both the Houses of Parliament a statement of estimated receipts and expenditure of the Government of India for that year. Filled circle. No demand for a grant shall be made except on the recommendation of the President. Filled circle. No money shall be withdrawn from the Consolidated Fund of India except under Appropriation made by law. Filled circle the expenditure charged on the Consolidated Fund of India shall not be submitted to the vote of Parliament. However, it can be discussed by the Parliament. Filled circle the voting of demands for grants is the exclusive privilege of the Lok Sabha, that is, the Rajya Sabha has no power of voting the demands. Filled circle Parliament can also move motions to reduce any demand for grants. Such motions are called as cut motion, which are of three kinds. A policy cut motion, it represents the disapproval of the policy underlying the demand. It states that the amount of the demand will be reduced to 1 rupee. B. Economy cut motion, it states that the amount of the demand be reduced by a specified amount. C. Token cut motion, it ventilates a specific grievance that is within the sphere of responsibility of the Government of India. It states that the amount of the demand will be reduced by 100 rupees. Filled circle the Constitution of India provides for the following three kinds of funds for the central government. 1. Consolidated Fund of India, Article 266, fund to which all receipts are credited and all payments are debited. All the legally authorized payments on behalf of the Government of India are made out of this fund. No money out of this fund can be appropriated, issued or drawn, except in accordance with a parliamentary law. UPSC 2011. 2. Public Account of India, Article 266, all other public money, other than those which are credited to the Consolidated Fund of India, received by or on behalf of the Government of India shall be credited to the Public Account of India, includes Provident Fund deposits, judicial deposits, savings bank deposits, departmental deposits, remittances and so on. This account is operated by executive action, that is, the payments from this account can be made without parliamentary appropriation. 3. Contingency Fund of India, Article 267, the Parliament enacted the Contingency Fund of India Act in 1950. This fund is placed at the disposal of the President, and he can make advances out of it to meet unforeseen expenditure pending its authorization by the Parliament. Position of Rajya Sabha. The constitutional position of the Rajya Sabha, as compared with the Lok Sabha, can be studied from three angles. 1. Where Rajya Sabha is equal to Lok Sabha. 2. Where Rajya Sabha is unequal to Lok Sabha. 3. Where Rajya Sabha has special powers that are not at all shared with the Lok Sabha. 53. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Equal status with LOKSABHA, RS equals LS, Filled circle Ordinary Bills, Filled circle Passage of Constitutional Amendment Bills, UPSC 2020. Unequal status with LOKSABHA, RS less than LS. Special powers to Rajya Sabha, RS greater than LS. Filled circle Financial Bill Type 2, Filled circle Election and Impeachment of President. Filled circle Election and removal of Vice President, RS can alone initiate removal. Filled circle Approval of Ordinance. Issued by President. Filled circle Approval for emergencies. Filled circle Money bills introduced only in LS, RS no power to amend or reject Money Bill, UPSC 2015. Filled circle Financial Bill Type 1. Introduced only in LS. Filled circle Speaker presides over joint sitting. Filled circle RS can only discuss budget but cannot vote on demand for grants, UPSC 2015. Filled circle Resolution for discontinuance of national emergency passed only by LS. Filled circle No confidence motion removal of government only initiated in LS, UPSC 2020. RS can authorize Parliament to make law on subject in state list, Art.249. RS can authorizes Parliament to create all India services common to both centre and state, Art.312. UPSC 2012 Special powers conferred to RS. Parliamentary privileges. Parliamentary privileges are special rights, immunities and exemptions enjoyed by the two houses of Parliament, their committees and their members. Parliamentary privileges also extend to the Attorney General of India and Union Ministers, but parliamentary privileges do not extend to the President, who is also an integral part of the Parliament. Originally, the Constitution, Article 105, expressly mentioned two privileges, that is, freedom of speech in Parliament and right of publication of its proceedings. Collective privileges. Individual privileges. 1. It has the right to publish its reports, debates and proceedings, and also the right to prohibit others from publishing the same. 2. It can exclude strangers from its proceedings and hold secret sittings. The privileges belonging to the members individually are: 1. They cannot be arrested during the session of Parliament and 40 days before the beginning and 40 days after the end of a session. Available only in civil cases and not in criminal cases. 54. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. 3. It can make rules to regulate its own procedure and the conduct of its business and to adjudicate. 4. It can punish members as well as outsiders for breach of its privileges. 5. It has the right to receive immediate information of the arrest, detention, conviction, imprisonment and release of a member. 6. The courts are prohibited to inquire into the proceedings of a house or its committees. 7. No person, either a member or outsider, can be arrested, and no legal process, civil or criminal, can be served within the precincts of the House without the permission of the presiding officer. 2. They have freedom of speech in Parliament. No member is liable to any proceedings in any court for anything said or any vote given by him in Parliament or its committees. 3. They are exempted from jury service. They can refuse to give evidence and appear as a witness in a case pending in a court when Parliament is in session. Breach of privilege and contempt of the House. When any individual or authority disregards or attacks any of the privileges, rights and immunities, either of the member individually or of the House in its collective capacity, the offense is termed as breach of privilege and is punishable by the House. Any act or omission which obstructs a House of Parliament, its member or its officer in the performance of their functions, treated as contempt of House. State Legislature, Part 6, Art.168-212. Filled circle. Presently 28 states and 8 UTs. Filled circle. Only 6 states have bicameral legislature: Andhra Pradesh, Telangana, Karnataka, Maharashtra, Uttar Pradesh, Bihar. Filled circle. Art.169. The Constitution provides for the abolition or creation of legislative councils in states if the Legislative Assembly of the concerned state passes a resolution to that effect. Such a specific resolution must be passed by the State Assembly by a special majority, that is, a majority of the total membership of the Assembly and a majority of not less than 2/3 of the members of the Assembly present and voting. Composition of two houses. Composition of Assembly. Composition of Council. Filled circle. Legislative Assembly consists of representatives directly elected by the people on the basis of universal adult franchise. Filled circle. Its maximum strength is fixed at 500 and minimum strength at 60. In case of Arunachal Pradesh, Sikkim and Goa, the minimum number is fixed at 30. Filled circle. The members of the Legislative Council are indirectly elected. Filled circle. The maximum strength of the Council is fixed at 1/3 of the total strength of the Assembly and the minimum strength is fixed at 40, UPSC 2015. 55. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Field Circle. The governor can nominate one member from the Anglo-Indian community, if the community is not adequately represented in the Assembly. Under the 95th Amendment Act of 2009, this is to last until 2020. Field Circle. The Constitution provided for the reservation of seats for scheduled castes and scheduled tribes in the Assembly of each state on the basis of population ratios. Field Circle. Though the Constitution has fixed the maximum and the minimum limits, the actual strength of a council is fixed by Parliament. Field Circle of the total number of members of a legislative council. 1. 1/3 are elected by the members of local bodies in the state like municipalities, district boards, etc. 2. 1/12 are elected by graduates of 3 years standing and residing within the state. 3. 1/12 are elected by teachers of 3 years standing in the state, not lower in standard than secondary school. 4. 1/3 are elected by the members of the Legislative Assembly of the state from amongst persons who are not members of the Assembly, and 5. 1/6 are nominated by the governor. Duration of council. Duration of Assembly. Field Circle. Its normal term is 5 years from the date of its first meeting after the general elections. Field Circle. However, the governor is authorized to dissolve the Assembly at any time, i.e., even before the completion of 5 years. Field Circle. Term of the Assembly can be extended during the period of national emergency by a law of Parliament for 1 year at a time, for any length of time. Field Circle. The Legislative Council is a continuing chamber, that is, it is a permanent body and is not subject to dissolution. Field Circle. 1/3 of its members retire on the expiration of every second year. So, a member continues as such for 6 years. Field Circle. The retiring members are also eligible for re-election and re-nomination any number of times. Speaker of Assembly. Field Circle. The Speaker is elected by the Assembly itself, from amongst its members. Field Circle remains in office during life of Assembly. Speaker of Legislative Assembly shall vacate office if he ceases to member of Assembly. UPSC 2018. Field Circle. Even if SLA dissolves, Speakers remains in office until next Speaker resumes office. Field Circle. He was removed by a resolution passed by a majority of all the then members of the Assembly. Such a resolution can be moved only after giving 14 days advance notice. Field Circle. He does not vote in the first instance, but he can exercise a casting vote in the case of a tie. Chairman of Council. Field Circle. The chairman is elected by the council itself from amongst its members. UPSC 2015. Field Circle. He can be removed by a resolution passed by a majority of all the then members of the council. Such a resolution can be moved only after giving 14 days advance notice. Field Circle. Speaker has one special power which is not enjoyed by Field Circle. The chairman. The Speaker decides whether a bill is a money bill or not, and his decision on this question is final. Deputy Speaker of Assembly. Deputy Chairman of Council. 56. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Field Circle. Deputy Speaker is also elected by the Assembly itself from amongst its members. Field Circle. He was removed by a resolution passed by a majority of all the then members of the Assembly. Such a resolution can be moved only after giving 14 days advance notice. Field Circle. The Deputy Speaker performs the duties of the Speaker's office when it is vacant. Field Circle. Deputy Chairman is also elected by the Council itself from amongst its members. Field Circle. He was removed by a resolution passed by a majority of all the then members of the Council. Such a resolution can be moved only after giving 14 days advance notice. Field Circle. The Deputy Chairman performs the duties of the Chairman's office when it is vacant. He also acts as the Chairman when the latter is absent from the sitting of the Council. Parliamentary Committees. Filled circle. The Constitution of India makes a mention of these committees at different places, but without making any specific provisions regarding their composition, tenure, functions. Filled circle. Committees appointed or nominated by Speaker, Chairman of that House. Filled circle. The Minister is not eligible for the Financial Committee, Departmental Committee, Women Empowerment, Government Assurance, Petitions and Welfare of SC Street Committees. 1. Financial Committees. Public Accounts Committee. Estimates Committee. Committee on Public Undertakings. Filled circle. Committee was set up first in 1921 under the provisions of the Government of India Act of 1919. Filled circle. It consists of 22 members, 15 from the Lok Sabha and 7 from the Rajya Sabha, UPSC 2013, 2007. Filled circle. The term of office of the members is 1 year. Filled circle. Since 1967 a convention has developed whereby the chairman of the committee is selected invariably from the opposition. Filled circle. The function of the committee is to examine the annual audit reports of the Controller and Auditor General of India, CAG, UPSC 2013, 2012. Filled circle. Set up in 1921. Filled circle. The first Estimates Committee in the post-independence era was constituted in 1950 on the recommendation of John Matai. Filled circle. 30 members. All the 30 members are from Lok Sabha only. Filled circle. It is largest committee of Parliament, UPSC. 2014. Filled circle. Rajya Sabha has no representation in this committee. Filled circle. The term of office is 1 year. Filled circle. Created in 1964 on the recommendation of the Krishna Menon Committee. Filled circle. In 1974, its membership was raised to 22, 15 from the Lok Sabha and 7 from the Rajya Sabha. Filled circle. The term of office of the members is 1 year. Filled circle. The chairman of the committee is appointed by the Speaker from amongst its members who are drawn from the Lok Sabha only. 57. Telegram. https://t.me/IAS Network. Website, www.IAS Network. Contact, 9,779,726,117. Filled circle. The function of the committee is to examine the estimates included in the budget and suggest economies in public expenditure. 2. Departmental Standing Committees, 24. 3. Committees to inquire, a. Committee on Petitions, b. Committee of Privileges, c. Ethics Committee. 4. Committees to scrutinize and control, a. Committee on Government Assurances, b. Committee on Subordinate Legislation scrutinizes and reports the House whether the power to make regulations, rules, sub-rules, by laws conferred by Constitution or delegated by Parliament are being properly exercised by executives, UPSC 2018, c. Committee on Papers laid on the table, d. Committee on Welfare of SCs and STs, e. Committee on Empowerment of Women, f. Joint Committee on Offices of Profit. 5. Committees relating to the day-to-day business of the House, a. Business Advisory Committee, b. Committee on Private Members' Bills and Resolutions, c. Rules Committee, d. Committee on Absence of Members from Sittings of the House. 6. Housekeeping Committees or Service Committees, i.e., committees concerned with the provision of facilities and services to members, a. General Purposes Committee, b. House Committee, c. Library Committee, d. Joint Committee on Salaries and Allowances of Members. Filled circle. Consultative Committee. These are not parliamentary committees. Minister of State is chairman. It is forum for informal discussion. It is constituted by Ministry of Parliamentary Affairs. Filled circle. Note: Attorney General and Vice President can be member of parliamentary committees. Parliamentary forums. Filled circle. The first parliamentary forum on water conservation and management was constituted in the year 2005. Filled circle. 7 more parliamentary forums were constituted. At present, there are 8 parliamentary forums. Filled circle objectives to provide a platform to the members to have interactions with the ministers concerned, experts and key officials from the nodal ministries, to sensitize members about the key areas of concern and also about the ground level situation and equip them with the latest information. 58. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled circle composition of forum. The Speaker of Lok Sabha is the ex officio president of all the forums except the Parliamentary Forum on Population and Public Health, wherein the chairman of Rajya Sabha is the ex officio president and the speaker is the ex officio co-president. Filled circle. Each forum consists of not more than 31 members, excluding the president, co-president and vice-presidents, out of whom not more than 21 are from the Lok Sabha and not more than 10 are from the Rajya Sabha. Filled circle. The duration of the office of members of the forum is coterminous with their membership in the respective houses. Parliamentary group. Filled circle. To promote inter-parliamentary relation. Filled circle. IPG that acts both as the national group of the Inter-Parliamentary Union, IPU, and also as the India branch of the Commonwealth Parliamentary Association, CPA. Filled circle. IPG is an autonomous body. It was formed in the year 1949. Filled circle. The Speaker of the Lok Sabha is the ex officio president of the group. Filled circle. The Deputy Speaker of the Lok Sabha and the Deputy Chairman of the Rajya Sabha are the ex officio vice presidents of the group. Filled circle. The Secretary General of the Lok Sabha acts as the ex officio Secretary General of the group. Supreme Court and High Court. Supreme Court, Part 5, Art. .124 to 147, High Court, Part 6, Art. 214 to 231, Filled circle. SC inaugurated, the 28th of January 1950, single system of courts, adopted from the Government of India Act of 1935, Filled circle. SC replaced British Privy Council in 1950. Filled circle. Constitution declares Delhi as seat, however CJI can appoint other places as seats. Filled circle. Parliament cannot curtail jurisdiction of SC, however Parliament can extend jurisdiction of SC. Filled circle. SC is custodian of Constitution of India, UPSC 2015. Composition and appointment of SC judges. Filled circle. In 2019, the Centre notified an increase in the number of Supreme Court judges from 31 to 34, including the Chief Justice of India. Filled circle. The institution of High Court originated in India in 1862 when the High Courts were set up at Calcutta, Bombay and Madras. In 1866, a fourth High Court was established at Allahabad. Filled circle. The Constitution of India provides for a High Court for each state, but the Seventh Amendment Act of 1956 authorized the Parliament to establish a common High Court for two or more states or for two or more states and a union territory. Filled circle. At present, 2019, there are 25 High Courts in the country. Composition and appointment of HC judges. Filled circle. Every High Court, whether exclusive or common, consists of a Chief Justice and such other judges as the President may from time to time deem necessary to appoint. 59. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled circle. The judges of the Supreme Court are appointed by the President. Filled circle. The Chief Justice is appointed by the President after consultation with such judges of the Supreme Court and High Courts. Filled circle. The other judges are appointed by President after consultation with the Chief Justice and such other judges of the Supreme Court and the High Courts. Filled circle. The consultation with the Chief Justice is obligatory in the case of appointment of a judge other than the Chief Justice. Filled circle. Third Justice case consultation of plurality judges. Qualification of judges. Filled circle. He should be a citizen of India. Filled circle. He should have been a judge of a high court for 5 years. Filled circle. He should have been an advocate of a high court for 10 years. Filled circle. He should be a distinguished jurist in the opinion of the President. Filled circle. Constitution has not prescribed a minimum age for appointment as a judge. Oath. Filled circle has to make and subscribe an oath or affirmation before the President. Tenure. Filled circle. The Constitution has not fixed the tenure of a judge of the Supreme Court. Filled circle. He holds office until he attains the age of 65 years, question regarding age determined by Parliament. Filled circle. He can resign his office by writing to the President. Filled circle. He can be removed from his office by the President on the recommendation of the Parliament. On grounds of 1. Misbehavior, 2. Incapacity. Removal of judges. Filled circle. The Judges Inquiry Act, 1968, regulates the procedure. Filled circle. The Constitution does not specify the strength of a high court and leaves it to the discretion of the President. Filled circle. The judges of a high court are appointed by the President. The Chief Justice is appointed by the President after consultation with the Chief Justice of India and the Governor of the state concerned. Filled circle. In 2015, the Supreme Court declared both the 99th Constitutional Amendment as well as the NJAC Act as unconstitutional and void. Qualification of judges. Filled circle. He should be a citizen of India. Filled circle. He should have held a judicial office in the territory of India for 10 years. Filled circle. He should have been an advocate of a high court or high courts in succession for 10 years. Filled circle. Constitution makes no provision for appointment of a distinguished jurist as a judge of a high court. Oath. Filled circle has to make and subscribe an oath or affirmation before the governor of the state. Tenure. Filled circle. The Constitution has not fixed the tenure of a judge of a high court. Filled circle. He holds office until he attains the age of 62 years. Filled circle. He can resign his office by writing to the President. Filled circle. He can be removed from his office by the President on the recommendation of the Parliament. On grounds of 1. Misbehavior. 2. Incapacity. Removal of judges. Filled circle. A judge of a high court can be removed from his office by an order of the President. Filled circle. A removal motion signed by 100 members, in the case of Lok Sabha, or 50 members, in the case of Rajya Sabha, is to be given to the Speaker, Chairman. Filled circle. After the motion is passed by each House of Parliament by special majority, an address is 60. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled circle. A removal motion signed by 100 members, in the case of Lok Sabha, or 50 members, in the case of Rajya Sabha, filled circle. The Speaker, Chairman may admit the motion or refuse to admit it. Filled circle. After the motion is passed by each House of Parliament by special majority, an address is presented to the President for removal of the judge. Filled circle. No judge of the Supreme Court has been impeached so far. Acting, ad hoc and retired judges. Acting Chief Justice. The President can appoint a judge of the Supreme Court as an acting Chief Justice of India. When office is vacant, CJI is absent, CJI is unable to perform. Ad hoc judge. When there is a lack of quorum of the permanent judges to hold or continue any session of the Supreme Court, the Chief Justice of India can appoint a judge of a high court as an ad hoc judge of the Supreme Court for a temporary period. Retired judge. At any time, the Chief Justice of India can request a retired judge of the Supreme Court or a retired judge of a high court to act as a judge of the Supreme Court for a temporary period. Jurisdiction and powers of Supreme Court. Original jurisdiction, UPSC 2012. Under Article 131, subject to the provisions of this Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction any dispute. I. Between the Government of India and states. E. Between the Government of India and any state or states on one side and one or more other. Presented to the President for removal of the judge. Filled circle. The procedure for the impeachment of a judge of a high court is the same as that for a judge of the Supreme Court. Filled circle. The President can transfer a judge from one high court to another after consulting the Chief Justice of India. Acting, additional and retired judges. Acting Chief Justice. The President can appoint a judge of the Supreme Court as an acting Chief Justice of HC. When office is vacant, CJ is absent, CJ is unable to perform. Additional and acting judges. The President can appoint duly qualified persons as additional judges of a high court for a temporary period not exceeding 2 years. Retired judges. At any time, the Chief Justice of a high court of a state can request a retired judge of that high court or any other high court to act as a judge of the high court of that state for a temporary period. Jurisdiction and powers of high court. Original jurisdiction. It means the power of a high court to hear disputes in the first instance, not by way of appeal. It extends to the following: a. Matters of admiralty and contempt of court. b. Disputes relating to the election of members of Parliament and state legislatures. c. Regarding revenue matters. An act ordered or done in revenue collection. d. Enforcement of fundamental rights of citizens. e. Cases ordered to be transferred from a subordinate court involving the interpretation of the Constitution to its own file. 61. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. E. States on the other, or between two or more states, if and insofar as the dispute involves any question on which the existence or extent of a legal right depends. Filled circle. The Supreme Court has exclusive original jurisdiction in the above cases. Exclusive means, no other court can decide such disputes, and original means, the power to hear such disputes in the first instance, not by way of appeal. Filled circle. Original jurisdiction does not extend to I. Pre-constitutional treaty. e. Interstate water disputes. e. Matter referring Finance Commission. Writ jurisdiction. Filled circle. The Supreme Court has original jurisdiction in the sense that an aggrieved citizen can directly go to the Supreme Court, not necessarily by way of appeal. However, the writ jurisdiction of the Supreme Court is not exclusive. Filled circle. SC can issue writ only for enforcement of FR. Appellate jurisdiction. Filled circle. It enjoys a wide appellate jurisdiction which can be classified under 4 heads. A. Appeals in constitutional matters. b. Appeals in civil matters. c. Appeals in criminal matters. d. Appeals by special leave. Advisory jurisdiction, UPSC 2010, filled circle. The Constitution, Article 143, authorizes the President to seek the opinion of the Supreme Court in the 2 categories of matters. A. On any question of law or fact of public importance which has arisen or which is likely to arise, Supreme Court may tender or may refuse to tender its opinion to the President. b. On any dispute arising out of any pre-Constitution treaty, agreement. Writ jurisdiction. Filled circle. Article 226 of the Constitution empowers a high court to issue writs. Filled circle. The writ jurisdiction of the High Court, under Article 226, is not exclusive but concurrent with the writ jurisdiction of the Supreme Court, under Article 32. Appellate jurisdiction. A high court is primarily a court of appeal. It hears appeals against the judgments of subordinate courts functioning in its territorial jurisdiction. It has appellate jurisdiction in both civil and criminal matters. Supervisory jurisdiction. A high court has the power of superintendence over all courts and tribunals functioning in its territorial jurisdiction, except military courts or tribunals. Power of judicial review. Judicial review is the power of a high court to examine the constitutionality of legislative enactments and executive orders of both the central and state governments. Though the phrase, judicial review, has nowhere been used in the Constitution, the provisions of Articles 13 and 226 explicitly confer the power of judicial review on a high court. The constitutional validity of a legislative enactment or an executive order can be challenged in a high court. A court of record. As a court of record, a high court has two powers. The judgments, proceedings and acts of the high courts are recorded for perpetual memory and testimony. These 62. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Supreme Court must tender its opinion to the President. Power of judicial review. Field Circle Judicial review is the power of the Supreme Court to examine the constitutionality of legislative enactments and executive orders of both the central and state governments. Constitutional interpretation. Field Circle The Supreme Court is the ultimate interpreter of the Constitution. Other powers of SC. Field Circle It decides the disputes regarding the election of the President and the Vice President. Field Circle inquires into the conduct and behavior of the chairman and members of the Union Public Service Commission. Field Circle It has the power to review its own judgment or order. Field Circle It has power of judicial superintendence and control over all the courts and tribunals functioning in the entire territory of the country. Important Articles 124a. National Judicial Appointments Commission 130. Seat of Supreme Court 141. Law declared by Supreme Court to be binding on all courts 142. Enforcement of decrees and orders of the Supreme Court and orders as to discovery, etc. 143. Power of President to consult Supreme Court. Records are admitted to be of evidentiary value and cannot be questioned when produced before any subordinate court. They are recognized as legal precedents and legal references. Opening parenthesis. B. It has power to punish for contempt of court, either with simple imprisonment or with fine or with both. The expression, contempt of court, has not been defined by the Constitution. However, the expression has been defined by the Contempt of Court Act of 1971. Important Articles 222. Transfer of a judge from one high court to another 227. Power of superintendence over all courts by the High Court. Judicial review. Field Circle The doctrine of judicial review originated and developed in the USA. 63. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Field Circle Supreme Court has declared the power of judicial review as a basic feature of the Constitution or an element of the basic structure of the Constitution. Field Circle MEANING Judicial review is the power of the judiciary to examine the constitutionality of legislative enactments and executive orders of both the central and state governments, UPSC 2017. Field Circle Judicial review is needed for the following reasons: to uphold the principle of the supremacy of the Constitution. B. To maintain federal equilibrium, balance between the center and the states. C. To protect the fundamental rights of the citizens. Field Circle Though the phrase, judicial review, has nowhere been used in the Constitution, the provisions of several articles explicitly confer the power of judicial review on the Supreme Court and the High Courts. Field Circle These provisions are explained below. 1. Article 13 declares that all laws that are inconsistent with or in derogation of the fundamental rights shall be null and void. 2. Article 32 guarantees the right to move the Supreme Court for the enforcement of the fundamental rights and empowers the Supreme Court to issue directions or orders or writs for that purpose. 3. Article 226 empowers the High Courts to issue directions or orders or writs for the enforcement of the fundamental rights and for any other purpose. 4. Article 372 deals with the continuance in force of the pre-Constitution laws. 5. Art. 131 sextillion 132 quintillion 134 quadrillion 136 trillion 143 billion 227,245,246, etc. Filled circle. The scope of judicial review in India is narrower than what exists in the USA, though the American Constitution does not explicitly mention the concept of judicial review in any of its provisions. Filled circle. This is because the American Constitution provides for due process of law, against that of procedure established by law, which is contained in the Indian Constitution. Judicial review of the 9th Schedule. Filled circle. Article 31b saves the acts and regulations included in the 9th Schedule from being challenged and invalidated on the ground of contravention of any of the fundamental rights. Filled circle. Article 31b along with the 9th Schedule was added by the first constitutional amendment. Act of 1951. Filled circle. Significant judgment delivered in IR. Coelho case, 2007, the Supreme Court ruled that there could not be any blanket immunity from judicial review of laws included in the 9th Schedule. The court held that judicial review is a basic feature of the Constitution and it could not be taken away by putting a law under the 9th Schedule. UPSC 2018, Filled circle. It said that the laws placed under the 9th Schedule after April 24, 1973, are open to challenge in court if they violated fundamental rights guaranteed under the Articles 14, 15, 19 and 21 or the basic structure of the Constitution. Filled circle. It was on April 24, 1973, that the Supreme Court first propounded the doctrine of basic structure, or basic features, of the Constitution in its landmark verdict in the Kesavananda Bharati case. Judicial activism. Filled circle. Concept of judicial activism originated and developed in the USA. 64. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled circle. In India, the doctrine of judicial activism was introduced in mid-1970s. Justice V.R. Krishna Iyer. Justice P.N. Bhagwati, Justice O. Chinnappa Reddy and Justice D.A. Desai. Filled circle. MEANING. Judicial activism denotes the proactive role played by the judiciary in the protection of the rights of citizens and in the promotion of justice in the society. In other words, it implies the assertive role played by the judiciary to force the other two organs of the government, legislature and executive, to discharge their constitutional duties. Filled circle. The concept of judicial activism is closely related to the concept of public interest litigation. PIL. Filled circle. Meaning of judicial restraint. Judicial activism and judicial restraint are the two alternative judicial philosophies in the United States. Those who subscribe to judicial restraint contend that the role of judges should be scrupulously limited. The job is merely to say what the law is, leaving the business of lawmaking where it properly belongs, that is, with the legislators and the executives. Public interest litigation, UPSC 2006. Filled circle. Justice V.R. Krishna Iyer and Justice P.N. Bhagwati were the pioneers of the concept of PIL. PIL is also known variously as social action litigation, SAL, social interest litigation, SIL, and class action litigation, CAL. Filled circle. In 1998, the Supreme Court formulated a set of guidelines to be followed for entertaining letters or petitions received by it as PIL. These guidelines were modified in 1993 and 2003. Tribunals. Filled circle. The original constitution did not contain provisions with respect to tribunals. The 42nd Amendment Act of 1976 added a new Part 14A to the Constitution. Filled circle. This part is entitled as Tribunals, and consists of only two articles. Article 323A dealing with administrative tribunals and Article 323B dealing with tribunals for other matters. Filled circle. Article 323A enables the Parliament to take out the adjudication of disputes relating to service matters from the civil courts and the high courts and place it before the administrative tribunals. Filled circle. Central Administrative Tribunal, CAT. The Central Administrative Tribunal, CAT, was set up in 1985 with the principal bench at Delhi and additional benches in different states. CAT was set up during presidentship of Rajiv Gandhi, UPSC 2009. Filled circle. The CAT exercises original jurisdiction in relation to recruitment and all service matters of public servants covered by it. Its jurisdiction extends to the All India Services, the Central Civil Services, civil posts under the centre and civilian employees of defence services. Filled circle. State Administrative Tribunals. The Administrative Tribunals Act of 1985 empowers the central government to establish the State Administrative Tribunals, SATs, on specific request of the concerned state governments. Filled circle. Article 323b. The Parliament and the state legislatures are authorized to provide for the establishment of tribunals for the adjudication of disputes relating to the following matters: a. Taxation, b. Foreign exchange, import and export, c. Industrial and labor, d. Land reforms, e. Ceiling on urban property, f. Elections to Parliament and state legislatures, g. Foodstuffs. Subordinate courts. Filled circle. Articles 233 to 237 in Part 6 of the Constitution make the following provisions to regulate the organization of subordinate courts and to ensure their independence from the executive. 65. Telegram. https://t.me/IAS Network website, www.IAS. Network contact, 9,779,726,117. Filled circle. The appointment, posting and promotion of district judges in a state are made by the governor of the state in consultation with the High Court. Filled circle. Appointment of persons, other than district judges, to the judicial service of a state are made by the governor of the state after consultation with the State Public Service Commission and the High Court. National Legal Services Authority. Filled circle. Article 39A of the Constitution of India provides for free legal aid to the poor and weaker sections of the society and ensures justice for all. Filled circle. Articles 14 and 22, 1, of the Constitution also make it obligatory for the state to ensure equality before law and a legal system which promotes justice on the basis of equal opportunity to all. Filled circle. In the year 1987, the Legal Services Authorities Act was enacted. Lok Adalats. Filled circle. The word, Lok Adalat, means, People's Court. This system is based on Gandhian principles. It is one of the components of the ADR, Alternative Dispute Resolution, system. Filled circle. As the Indian courts are overburdened with the backlog of cases and the regular courts are to decide the cases involving a lengthy, expensive and tedious procedure. Filled circle. The first Lok Adalat camp in the post-independence era was organized in Gujarat in 1982. Filled circle. Lok Adalat has been given statutory status under the Legal Services Authorities Act, 1987. Filled circle. There is no court fee, and if court fee is already paid, the amount will be refunded if the dispute is settled at Lok Adalat. Filled circle. The award by the Lok Adalat is binding on the parties and it has the status of a decree of a civil court and it is non-appealable. Permanent Lok Adalats statutory. Filled circle. The Legal Services Authorities Act, 1987 was amended in 2002 to provide for the establishment of the permanent Lok Adalats to deal with cases pertaining to the public utility services. Field Circle. The permanent Lok Adalat shall consist of a chairman who is or has been a district judge or additional district judge or has held judicial office higher in rank than that of the district judge. Field Circle. No jurisdiction on non-compoundable laws. Field Circle. The pecuniary jurisdiction of the permanent Lok Adalat shall be up to Rs 10 lakhs. Field Circle. Every award made by the permanent Lok Adalat shall be final and binding on all the parties thereto and shall be by a majority of the persons constituting the permanent Lok Adalat. Family Courts. Statutory. Field Circle. Specialized court, exclusively family matters. Field Circle established by state government. Consulting HC. Field Circle. Obligatory to set up court in city 1 million population. Field Circle provides only one right to appeal, which shall lie to High Court. Gram Nyayalayas, UPSC 2016. 66. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Field Circle. Gram Nyayalayas Act, 2008 has been enacted to provide for the establishment of the Gram Nyayalayas at the grassroots level for the purposes of providing access to justice to the citizens at the doorsteps. Field Circle. The Gram Nyayalaya shall be the court of judicial magistrate of the first class, and its presiding officer, Nyayadhikari, shall be appointed by the state government in consultation with the High Court. Field Circle. The Gram Nyayalaya shall be a mobile court and shall exercise the powers of both criminal and civil courts. Field Circle. The Gram Nyayalaya shall try to settle the disputes as far as possible by bringing about conciliation between the parties, and for this purpose, it shall make use of the conciliators to be appointed for this purpose. Field Circle. The Gram Nyayalaya shall not be bound by the rules of evidence provided in the Indian Evidence Act, 1872, but shall be guided by the principles of natural justice and subject to any rule made by the High Court. Field Circle. Appeal in criminal cases shall lie to the Court of Session, which shall be heard and disposed of within a period of 6 months from the date of filing of such appeal. Special provisions for some states. Part 21, Art.371-0371J. Field Circle. Articles 371 to 371J in Part 21 of the Constitution contain special provisions for 12 states, viz., Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Goa and Karnataka. Field Circle. Originally, the Constitution did not make any special provisions for these states. Field Circle. 371. Special provision with respect to the states of Maharashtra and Gujarat, 7th Const. AMD. Field Circle. 371A. Special provision with respect to the state of Nagaland, 13th Const. AMD, Field Circle. 371B. Special provision with respect to the state of Assam, 22nd Const. AMD. Field Circle. 371C. Special provision with respect to the state of Manipur, 27th Const. AMD. Field Circle. 371D. Special provisions with respect to the state of Andhra Pradesh or the state of Telangana. 32nd Const. AMD. Field Circle. 371E. Establishment of Central University in Andhra Pradesh. Field Circle. 371F. Special provisions with respect to the state of Sikkim, 36th Const. AMD. Full statehood, Field Circle. 371G. Special provision with respect to the state of Mizoram, 53rd Const. AMD. Field Circle. 371H. Special provision with respect to the state of Arunachal Pradesh, 55th Const. AMD. Field Circle. 371I. Special provision with respect to the state of Goa, 56th Const. AMD. Field Circle. 371J. Special provisions with respect to the state of Karnataka, 98th Const. AMD. Part 5. Local Government. PANCHAYATI Raj, Part 9, 11th Schedule. Filled Circle. It is entrusted with rural development. It was constitutionalized through the 73rd Constitutional Amendment Act of 1992. Filled Circle. Local self-government best explained as Exercise in Democratic Decentralization, UPSC 2017. 67. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled Circle. Fundamental objective of Panchayati Raj people's participation in development and democratic decentralization, UPSC 2015. Evolution of PANCHAYATI Raj. Filled Circle. Balwant Rai Mehta Committee, January 1957, recommended three-tier Panchayati Raj system. Filled Circle. Ashok Mehta Committee, December 1977, recommended two-tier Panchayati Raj system. Filled Circle. GVK Rao Committee, 1985, recommended two-tier Panchayati Raj system. Filled Circle. Dantwala Com. 1978, block-level planning. Filled Circle. Hanumantha Rao Com, district planning. Filled Circle. LM Singhvi, 1986, revitalization of Panchayati Raj. Filled Circle. Thungan Committee, 1988, recommended three-tier Panchayati Raj system. Filled Circle. Gajal Committee, 1988, recommended three-tier Panchayati Raj system. 73rd Amendment ACT of 1992, UPSC 2011. Filled Circle. This Act has added a new Part 9 to the Constitution of India. This part is entitled as the Panchayats and consists of provisions from Articles 243 to 243(0). Filled Circle. This schedule contains 29 functional items of the Panchayats. It deals with Article 243(g). Filled Circle. Gram Sabha. The Act provides for a Gram Sabha as the foundation of the Panchayati Raj system, body of persons registered in the electoral rolls of a village comprising the area of Panchayat at the village level. Thus, it is a village assembly consisting of all the registered voters in the area of a Panchayat. Filled Circle. Three-tier system. The Act provides for a three-tier system of Panchayati Raj in every state, that is, Panchayats at the village, intermediate, and district levels. Filled Circle. Election of members and chairpersons. All the members of Panchayats at the village, intermediate and district levels shall be elected directly by the people. Filled Circle. Reservation of seats. The Act provides for the reservation of seats for scheduled castes and scheduled tribes in every Panchayat, i.e., at all the three levels, in proportion of their population to the total population in the Panchayat area. The Act provides for the reservation of not less than one-third of the total number of seats for women. Filled Circle. Duration of Panchayats. The Act provides for a 5-year term of office to the Panchayat at every level. However, it can be dissolved before the completion of its term. Further, fresh elections to constitute a Panchayat shall be completed, a. before the expiry of its duration of 5 years, or b. in case of dissolution, before the expiry of a period of 6 months from the date of its dissolution. Panchayat continues only for remainder period after reconstituted, UPSC 2016, 2009. Filled Circle. Disqualifications. A person shall be disqualified for being chosen as or for being a member of Panchayat if he is so disqualified, a. under any law for the time being in force for the purpose of elections to the legislature of the state concerned, or b. under any law made by the state legislature. However, no person shall be disqualified on the ground that he is less than 25 years of age if he has attained the age of 21 years, UPSC 2016. Filled Circle. State Election Commission. The superintendence, direction and control of the preparation of electoral rolls and the conduct of all elections to the Panchayats shall be vested in the State Election Commission. It consists of a State Election Commissioner to be appointed by the Governor. His conditions of service and tenure of office shall also be determined by the Governor. Removal on the grounds removal of H.C. Judge. 68. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Field Circle State Finance Commission. The governor of a state shall, after every 5 years, constitute a finance commission to review the financial position of the panchayats. Governor is principal for determining the taxes and duties which may be appropriated. BT Panchayat, UPSC 2010. Compulsory Provisions 0F 73rd AMD Act 1992. 1. Organization of Gram Sabha in a village or group of villages. 2. Establishment of panchayats at the village, intermediate and district levels. 3. Direct elections to all seats in panchayats at the village, intermediate and district levels. 4. Indirect elections to the post of chairperson of panchayats at the intermediate and district levels. 5. Voting rights of the chairperson and other members of a panchayat elected directly or indirectly. 6. 21 years to be the minimum age for contesting elections to panchayats. 7. Reservation of seats, both members and chairpersons, for SCs and STs in panchayats at all the 3 levels. 8. Reservation of 1/3 seats, both members and chairpersons, for women in panchayats at all the 3 levels. 9. Fixing tenure of 5 years for panchayats at all levels and holding fresh elections within 6 months in the event of supersession of any panchayat. 10. Establishment of a state election commission for conducting elections to the panchayats. 11. Constitution of a state finance commission after every 5 years to review the financial position of the panchayats. PESA ACT of 1996, Extension ACT, UPSC 2013, 2012. Field Circle. The provisions of Part 9 of the Constitution relating to the panchayats are not applicable to the 5th Schedule areas. However, the Parliament may extend these provisions to such areas, subject to such exceptions and modifications as it may specify. Under this provision, the Parliament has enacted the Provisions of the Panchayats, Extension to the Scheduled Areas, Act, 1996, popularly known as the PESA Act or the Extension Act. Field Circle. At present, 2019, 10 states have 5th Schedule areas. Field Circle. Every village shall have a Gram Sabha consisting of persons whose names are included in the electoral rolls for the panchayat at the village level. Field Circle. To recognize traditional rights. Field Circle. Free tribal people from exploitation and provide self-governance. Field Circle. Every panchayat at the village level shall be required to obtain from the Gram Sabha a certification of utilization of funds for the above plans, programs and projects. Field Circle. The reservation of seats in the scheduled areas in every panchayat shall be in proportion to the population of the communities for whom reservation is sought to be given under Part 9 of the Constitution. However, the reservation for the scheduled tribes shall not be less than 1/2 of the total number of seats. Further, all seats of chairpersons of panchayats at all levels shall be reserved for the scheduled tribes. Field Circle. Planning and management of minor water bodies in the scheduled areas shall be entrusted to panchayats at the appropriate level. Field Circle. The prior recommendation of the Gram Sabha or the panchayats at the appropriate level shall be mandatory for grant of concession for the exploitation of minor minerals by auction. 69. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Municipalities, Part 9A, 12th Schedule. Field Circle. Urban local government, in India signifies the governance of an urban area by the people through their elected representatives. Field Circle. The system of urban government was constitutionalized through the 74th Constitutional Amendment Act of 1992. Field Circle at the central level, the subject of urban local government is dealt with by the following three ministries: I. Ministry of Housing and Urban Affairs. E. Ministry of Defense in the case of cantonment boards. E. Ministry of Home Affairs in the case of Union territories. Field Circle. Lord Mayo's resolution of 1870 on financial decentralization visualized the development of local self-government institutions. Lord Ripon's resolution of 1882 has been hailed as the Magna Carta of local self-government. He is called as the father of local self-government in India. The Royal Commission on Decentralization was appointed in 1907 and it submitted its report in 1909. 74th Amendment ACT of 1992. Field Circle. The 74th Amendment Act has added a new Part 9A to the Constitution of India. This part consists of provisions from Articles 243p to 243zg. Field Circle. In addition, the Act has also added a new 12th schedule to the Constitution. This schedule contains 18 functional items of municipalities. Field Circle. It deals with Article 243w. Field Circle. All the members of a municipality shall be elected directly by the people of the municipal area. For this purpose, each municipal area shall be divided into territorial constituencies to be known as wards. Field Circle. The Act provides for the reservation of seats for the scheduled castes and the scheduled tribes in every municipality in proportion of their population to the total population in the municipal area. Further, it provides for the reservation of not less than 1/3 of the total number of seats for women, including the number of seats reserved for women belonging to the SCs and the STs. Field Circle. The Act provides for a 5-year term of office for every municipality. However, it can be dissolved before the completion of its term. Further, the fresh elections to constitute a municipality shall be completed, a. Before the expiry of its duration of 5 years, or b. In case of dissolution, before the expiry of a period of 6 months from the date of its dissolution. Field Circle. A person shall be disqualified for being chosen as or for being a member of a municipality if he is so disqualified, a. Under any law for the time being in force for the purposes of elections to the legislature of the state concerned, or b. Under any law made by the state legislature. However, no person shall be disqualified on the ground that he is less than 25 years of age if he has attained the age of 21 years. Types of urban governments. 1. Municipal corporation. Municipal corporations are created for the administration of big cities like Delhi, Mumbai, Kolkata, Hyderabad, Bangalore and others. A municipal corporation has 3 authorities, namely, the council, the standing committees and the commissioner. The council is headed by a mayor. He is assisted by a deputy mayor. He is elected in a majority of the states for a 1-year renewable term. The municipal commissioner is appointed by the state government and is generally a member of the IAS. 70. Telegram. https://t.me/IAS Network website, www.IAS. Network contact, 9,779,726,117. 2. Municipality. The municipalities are established for the administration of towns and smaller cities. The Chief Executive Officer, Chief Municipal Officer is responsible for day-to-day general administration of the municipality. He is appointed by the state government. 3. Notified Area Committee. A notified area committee is created for the administration of 2 types of areas: a fast-developing town due to industrialization, and a town which does not yet fulfill all the conditions necessary for the constitution of a municipality. But unlike the municipality, it is an entirely nominated body, that is, all the members of a notified area committee including the chairman are nominated by the state government. 4. Town Area Committee. A town area committee is set up for the administration of a small town. It is a semi-municipal authority and is entrusted with a limited number of civic functions like drainage, roads, street lighting, and conservancy. It is created by a separate act of a state legislature. 5. Cantonment Board. A cantonment board is established for municipal administration for civilian population in the cantonment area. It is set up under the provisions of the Cantonments Act of 2006, a legislation enacted by the central government. A cantonment board consists of partly elected and partly nominated members. The elected members hold office for a term of 5 years, while the nominated members, i.e., ex officio members, continue so long as they hold the office in that station. 6. Township. This type of urban government is established by the large public enterprises to provide civic amenities to its staff and workers who live in the housing colonies built near the plant. No elected members. 7. Port Trust. The port trusts are established in the port areas like Mumbai, Kolkata, Chennai and so on for two purposes: a. To manage and protect the ports, and b. To provide civic amenities. A port trust is created by an Act of Parliament. Part 6. Union Territories and Special Areas. Union Territories, Part 8, Art. .239-241. Filled Circle. Article 1 of the Constitution. The territory of India comprises 3 categories of territories: a. Territories of the states, b. Union territories, and c. Territories that may be acquired by the Government of India at any time. Filled Circle. During British rule, certain areas were constituted as scheduled districts in 1874. Later, they came to be known as Chief Commissioners' Provinces. Filled Circle. In 1956, they were constituted as the Union Territories by the 7th Constitutional Amendment Act, 1956, and the States Reorganization Act, 1956. Filled Circle. Himachal Pradesh, Manipur, Tripura, Mizoram, Arunachal Pradesh and Goa, which are states today, were formerly union territories. Filled Circle. At present, there are 8 union territories. They are, along with the year of creation: 1. Andaman and Nicobar Islands 1956, 2. Delhi 1956, 3. Lakshadweep 1956, 4. Puducherry 1962, 5. Chandigarh 1966, 6. Jammu and Kashmir 2019 and 7. Ladakh 2019, 8. Dadra and Nagar Haveli and Daman and Diu 2019. Filled Circle. Every union territory is administered by the President acting through an administrator appointed by him. An administrator of a union territory is an agent of the President and not head of state like a governor. 71. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Filled Circle. The President can specify the designation of an administrator. It may be Lieutenant Governor or Chief Commissioner or Administrator. Filled Circle. At present, it is Lieutenant Governor in the case of Delhi, Puducherry, Andaman and Nicobar Islands, Jammu and Kashmir and Ladakh, and Administrator in the case of Chandigarh, Dadra and Nagar Haveli, Daman and Diu and Lakshadweep. Filled Circle. The Union Territories of Puducherry, in 1963, Delhi, in 1992, and Jammu and Kashmir, in 2019, are provided with a Legislative Assembly and a Council of Ministers headed by a Chief Minister. Filled Circle. The Bombay High Court has jurisdiction over 2 union territories: Dadra and Nagar Haveli, and Daman and Diu. Andaman and Nicobar Islands, Chandigarh, Lakshadweep and Puducherry are placed under the Calcutta, Punjab and Haryana, Kerala, and Madras High Courts respectively. The Jammu and Kashmir High Court is the common high court for the 2 union territories of Jammu and Kashmir, and Ladakh. Special provisions for Delhi. The 69th Constitutional Amendment Act of 1991 provided a special status to the Union Territory of Delhi, and redesignated it the National Capital Territory of Delhi and designated the Administrator of Delhi as the Lieutenant Governor. It created a legislative assembly and a council of ministers for Delhi. The chief minister is appointed by the president, not by the lieutenant governor. The other ministers are appointed by the president on the advice of the chief minister. The ministers hold office during the pleasure of the president. Scheduled and Tribal Areas, Part 10, Art. .244. Filled Circle Article 244 in Part 10 of the Constitution envisages a special system of administration for certain areas designated as scheduled areas and tribal areas. Filled Circle. The fifth schedule of the Constitution deals with the administration and control of scheduled areas and scheduled tribes in any state except the four states of Assam, Meghalaya, Tripura and Mizoram. UPSC 2015, 2008. Filled Circle. The sixth schedule of the Constitution, on the other hand, deals with the administration of the tribal areas in the four northeastern states of Assam, Meghalaya, Tripura and Mizoram. UPSC 2015. Filled Circle. Declaration of Scheduled Areas. The President is empowered to declare an area to be a scheduled area. He can also increase or decrease its area, alter its boundary lines, rescind such designation or make fresh orders for such designation on an area in consultation with the governor of the state concerned. Filled Circle. Executive power of state and center. The executive power of a state extends to the scheduled areas therein. But the governor has a special responsibility regarding such areas. Filled Circle. Law applicable to scheduled areas. The governor is empowered to direct that any particular act of parliament or the state legislature does not apply to a scheduled area or apply with specified modifications and exceptions. Filled Circle. The Constitution, under 6th Schedule, contains special provisions for the administration of tribal areas in the four northeastern states of Assam, Meghalaya, Tripura and Mizoram. Filled Circle. The governor is empowered to organize and reorganize the autonomous districts. Thus, he can increase or decrease their areas or change the names. Filled Circle. The acts of parliament or the state legislature do not apply to autonomous districts and autonomous regions or apply with specified modifications and exceptions. 72. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Constitutional bodies. Union Public Service Commission Art. 315 to 323 of Part 14. Composition. Chairman and AD members appointed by President. Term 6 years or till age of 65 years. Qualification. No prescribed qualification, else 50% member holds field experience for 10 years. Removal. Removal by President on basis of insolvent, office of profit or infirmity of minds or body and misbehavior under Article 319. Supreme Court advice is binding in nature, for removal. Members not eligible for employment other than chairman of UPSC or SPSC once only. Role. Its role is as watchdog of merit system, advisory recommendations and only a central recruiting agency. Election Commission of India. Article 324 establishes ECI as All India body. State Public Service Commission. Article 315 to 323 in Part 14. Composition. Chairman and AD members appointed by governor, term for 6 or till age of 62 year. Qualification. No qualification, else 50% members have field experience for 10 years. Removal. Remove only by President on the same ground as UPSC chairman or members can be removed. Enjoy security of junior new employment other than UPSC chairman or members, and no second term. Their role is the same as UPSC but for the state. Under Article 324, Election Commission is 3-member body. Chief Election Commission, CEC, and 2 Election Commissioner, EC, can be appointed by President for 6 or till age of 65 years and condition of services are determined by President. UPSC 2017. CEC can be removed in the manner and same on the ground of Supreme Court judges. EC removed by President on recommendation of CEC. The Chief Election Commissioner and the two other election commissioners have equal powers and receive equal salary, allowances and other perquisites, which are similar to those of a judge of the Supreme Court. They have power, administrative, advisory and quasi-judicial. Election Commission resolves the disputes relating to splits, mergers of recognized political parties UPSC 2017. Finance Commission Article 280 provides for a Finance Commission, constituted by the President for 5 years. FC is balancing wheel of fiscal federalism. It recommends distribution of tax revenues and it is a quasi-judicial body. It has a chairman and 4 other members who can be appointed by the President and work for a specialized period. Their qualification are decided by Parliament as chairman, having experience in public affairs. The 4 other members 1. A judge of the High Court or one qualified to be appointed as one. 2. A person who has specialized knowledge of finance and accounts of the government. 3. A person who has wide experience in financial matters and in administration. 4. A person who has special knowledge of economics. 73. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. No prescribed qualification, no specific term of office of members and no appointment other than CEC by promotions for EC and no appointment for CEC. Chairman and members of FC are eligible for reappointment for second term. Recommendations of FC are only of advisory nature, not binding on government. GST Council Article 279A added by 101st Constitution Amendment Act 2016, to makes recommendations to the Union and state government on issues related to goods and service tax. The GST Council, chaired by the Union Finance Minister and other members are the Union State Minister of Revenue or Finance and ministers in charge of finance or taxation of all the states. It is considered as a federal body where both the center and the states get due representation. Every decision of the Goods and Services Tax Council shall be taken at a meeting by a majority of not less than 3/4 of the weighted votes of the members present and voting, in accordance with the following principles, namely, central government vote 1/3 road, state government vote 2/3 road. Controller and Auditor General, CAG, Article 148 CAG as head of Indian Audit and Account Department is the guardian of public purse at center at any state level. Appointed by President by warrant under his hand and seal for 6 or till age of 65 years. Can be removed by the President on the same grounds of judges of the Supreme Court. No reappointment and no minister represents him in the Parliament. Article 149 prescribes duties of CAG to be set by Parliament, under CAG Act 1971. CAG audits all of the funds centre and state, related to Consolidated Fund of India, Contingency Fund of India and Public Account of India and respectively for states. CAG reports on execution of projects or programs by ministries are discussed by the Public Account Committee UPSC 2012. Provides its report to the President under Article 151. The 3 reports are audit on, appropriation account, finance account and public undertakings. Article 279 CAG ascertains and certifies the net proceeds of any tax and that is final. CAG Agent of Element. About National Commission for Scheduled Tribes, NCST, a new Article 338A in the Constitution through the Constitution, 89th Amendment, Act, 2003. National Commission for Scheduled Castes, Part 16, Article 338, by Constitution, 89th Amendment, Act, 2003, in 2004. It consists of a chairperson, a vice-chairperson and 3 other members. They are appointed by the President by warrant under his hand and seal. Term 3 years. Functions. Composition of NCST. The Commission comprises a chairperson, a vice-chairperson and 3 full-time members, including 1 lady member. The term of office chairperson, vice-chairperson and member of NCST is 3 years from the date of assumption of charge. 74. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. To investigate, monitor, inquire, advise, and participate in the planning process. It presents its report annually to the President. It has power of civil court and acts as same. Provide the scheduled castes of Indian society safeguards against exploitation and to promote their social, economic, educational and cultural development. The chairperson has been given the rank of Union Cabinet Minister. The vice-chairperson has the rank of a Minister of State and other members have the rank of a Secretary to the Government of India. Functions of NCST. Constitution of India under Clause 5 of Article 338A has assigned the following duties and functions to the Commission: to investigate, monitor, inquire, advise, and participate in the planning process. It presents its report annually to the President. It has the power of civil court and acts the same. Special Officer for Linguistic Minority. The 7th Constitutional Amendment Act of 1956 inserted a new Article 350B in Part 17 of the Constitution. National Commission for Backward Classes. 102nd Constitution Amendment Act, 2018 provides constitutional status to the National Commission for Backward Classes, NCBC, under Art. 338B. The Commission consists of 5 members including a chairperson, vice-chairperson and 3 other members appointed by the President by warrant under his hand and seal. Term 3 years. The conditions of service and tenure of office of the chairperson, vice-chairperson and other members is determined by the President. Its functions are to investigate, monitor, inquire, advise, and participate in the planning process. It presents its report annually to the President. It has the power of civil court and acts the same. Attorney General of India, UPSC. It contains the following provisions: there should be a special officer for linguistic minorities. He is to be appointed by the President of India. It would be the duty of the special officer to investigate all matters relating to the safeguards provided for linguistic minorities under the Constitution. He would report to the President upon those matters at such intervals as the President may direct. The President should place all reports before each House and send it to the governments of the states concerned. Constitution does not specify qualifications, tenure, removal. 2013. The Attorney General, AG, part of the Union Executive and highest law officer in the country under Art. 76. AG is appointed by the President on the advice of the government as person qualified to be Advocate General for the State, UPSC 2009. The Governor of each state shall appoint a person who is qualified to be appointed a judge of a high court to be Advocate General for the state under Art. 165. It shall be the duty of the Advocate General to give advice to the government of the state upon such legal matters, and to perform such other duties of a legal character, as may from time to time be referred or. 75. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Appointed a judge of the SC, or an eminent jurist, in the opinion of the President. Term of the office, not fixed. Removal. Holds office during the pleasure of the President, may be removed by the President at any time. To give advice to the Government of India, GOI, upon such legal matters, which are referred to her, him by the President. Appear on behalf of government in all cases in SC. Attorney General has right to audience in all courts, right to speak in Parliament without entitled to vote. Attorney General is not full-time counsel of government. He is not debarred from private legal practice assigned to him by the governor, and to discharge the functions conferred on him by or under this Constitution or any other law for the time being in force. The Advocate General shall hold office during the pleasure of the governor, and shall receive such remuneration as the governor may determine. Holds the right to speak in the State Assembly but not the right to vote. Non-constitutional bodies. National Institution for Transforming India, Niti Aayog, extra-constitutional body formed via a resolution of the Union Cabinet on Jan. 1, 2015 as Premier Policy, think tank, of Government of India to thereby fosters cooperative federalism. Bottom-up approach. Structure. Chairperson, the Prime Minister. Governing Council. Headed by the Prime Minister, it comprises the Chief Ministers of all states, UTs, and the Lieutenant Governors, administrators of UTs without a legislature. Regional councils. These can be constituted to address specific issues which, in the opinion of the Prime Minister, can affect more than one state in a region. These councils can be headed by the Prime Minister or his nominee and include the Chief Ministers and Lieutenant. Lokpal and Lokaayukta. Lokpal. Under the 2013 Act, the Lokpal one chairperson and not exceeding 8, of whom 50% should be judicial members. And Act states that not less than 50% from among persons belonging to the SCs, the STs, OBCs, minorities and women. Selection procedure. A search committee will prepare a panel of candidates. A selection committee, PM plus Speaker plus Leader of Opposition plus CJI plus one jurist, will recommend names from among this panel and the President will appoint these as members. Salaries and allowances. Salaries, allowances and service conditions same as those for the Chief Justice of India, for other members, same as those for a judge of the Supreme Court. Jurisdiction of Lokpal for a wide range of public servants, from the Prime Minister, ministers and 76. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Governors, administrators of states, UTs in the region. The full-time organizational framework of the Aayog consists of Vice Chairperson who is in charge of its everyday activities. He has the rank of a cabinet minister. 4 full-time members who have the rank of Minister of State at the union level. 2 part-time members who are academics from leading universities, research organizations etc. They are appointed on a rotational basis. Union Cabinet ministers, not exceeding 4, are nominated by the Prime Minister as ex officio members. A Chief Executive Officer who has a rank of Secretary to the Government of India is appointed by the Prime Minister. He has a fixed tenure and serves as the Member Secretary to the Aayog. Functions performed by the Niti Aayog can be divided into 4 main heads. 1. Design policy and program framework. 2. Foster cooperative federalism. 3. Monitoring and evaluation. 4. Think tank, and knowledge and innovation hub. MPs, to Groups A, B, C and D employees of the central government, various rules are in place. Even its own members. Exception of inquiry in certain cases. The Act does not allow Lokpal inquiry if the allegation against the Prime Minister relates to international relations, external and internal security, public order, atomic energy and space. Complaints against the Prime Minister are not to be probed unless the full Lokpal bench considers the initiation of an inquiry and at least 2/3 of the members approve it and such an inquiry against the Prime Minister. Inquiry. The Lokpal, after receiving a complaint against any public servant, orders a preliminary inquiry, to be completed within 90 days, or investigation by any agency. After receiving the report of the preliminary inquiry, the Lokpal may order an investigation by any agency or departmental proceedings or any other appropriate action against the concerned public servants by the competent authority, or it can order the closure of the proceedings. Lokpal cannot take suo moto against public servant. Lokayuktas, they are state equivalents of the central Lokpal. Every state shall establish a body to be known as the Lokayukta for the state, if not so established, constituted or appointed, by a law made by the state legislature, to deal with complaints relating to corruption against certain public functionaries, within a period of 1 year from the date of commencement of this act. Term 5 years or until age of 65 years. Not eligible for reappointment for second term. Recommendations made by Lokayukta are only advisory, not binding on state government. State Human Rights Commission, SHRC. The Protection of Human Rights Act of 1993 provides for the creation of State Human Rights Commission at the state level. National Human Rights Commission, NHRC. It is a statutory body. NHRC was established on 12 October 1993 under the Protection of Human Rights Act, PHRA, 1993. The Act also provides for the creation of the State Human Rights Commission as well. Can inquire into violation of human rights related to subjects covered under State List and Concurrent List in the 7th Schedule of the Indian Constitution. 77. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. The NHRC is an embodiment of India's concern for the promotion and protection of human rights. The Commission is a multi-member body consisting of a chairman and 5 members. The chairperson is a retired Chief Justice of India or a judge of the Supreme Court. They are appointed by the President on the recommendations of a 6-member committee consisting of Prime Minister, Head, Speaker of the Lok Sabha, Deputy Chairman of the Rajya Sabha, leaders of the opposition in both the Houses of Parliament, Union Home Minister. They hold office for a term of 3 years or until they attain the age of 70 years, whichever is earlier. The President can remove them from the office under specific circumstances. Central Information Commission established by the central government in 2005, under the provisions of the Right to Information Act 2005. It is not a constitutional body. The Commission consists of a Chief Information Commissioner and not more than 10 Information Commissioners. Appointment by the President on the recommendation of a committee consisting of the Prime Minister as chairperson, the Leader of Opposition in the Lok Sabha and a Union Cabinet Minister nominated by the Prime Minister. Tenure. The Chief Information Commissioner and an Information Commissioner shall hold office for such term as prescribed by the central government or until they attain the age of 65 years, whichever is earlier. They are not eligible for reappointment. Power and functions of CIC. It is the duty of the Commission to receive and inquire into a. The Governor of the State appoints the chairperson and other members on the recommendations of a committee consisting of Chief Minister as its head, Speaker of the Legislative Assembly, the State Home Minister, the Leader of the Opposition in the Legislative Assembly. In case the state has Legislative Council, the Chairman and the Leader of the Opposition of Legislative Council would also be the members of the committee. The chairman or any other member is removable by the President on the charge of proved misbehavior or incapacity after a regular inquiry by a judge of the Supreme Court. State Information Commissioner. It is an independent, statutory committee formed under the RTI Act to ensure freedom of information to citizens. It has jurisdiction over state government bodies, PSU and authorities. Composition: Chief Information Commissioner and up to 10 Information Commissioners. All are appointed by the Governor on recommendation of the Chief Minister, Cabinet Minister nominated by him and Leader of Opposition in Legislative Assembly. Qualification for membership to commission are persons of eminence in public life with experience in the field of law, science and technology, governance, social service, management, journalism, mass media or administration. They should not be MP, MLAs or connected to any political party, doing some business, profession or holding office of profit. They hold office till the age of 65 or 5 years. The Information Commissioner is eligible for the post of State Chief Information Commissioner but can be in office for a maximum of 5 years including his tenure as Information Commissioner. Removal is done by the Governor on grounds of bankruptcy, unsound mind, infirmity of body or mind, sentenced to imprisonment for a crime, or engaged in paid employment. 78. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Complaint from any person regarding information request under RTI, 2005. The Commission can order an inquiry into any matter if there are reasonable grounds, suo motu power. While inquiring, the Commission has the powers of a civil court in respect of summoning, requiring documents etc. Removal is done by the President on grounds of bankruptcy, unsound mind, infirmity of body or mind, sentenced to imprisonment for a crime, or engaged in paid employment. He can also be removed for proved misbehavior or incapacity if SC inquiry finds him guilty. They can resign by writing to the President. Central Bureau of Investigation Step List in 1963 by resolution of Ministry of Home Affairs, but not statutory body. And derives its powers from the Delhi Special Police Establishment Act, 1946. He can also be removed for proved misbehavior or incapacity if SC inquiry finds him guilty. They can resign by writing to the Governor. Establishment of CBI recommended by K. Santhanam Committee. CBI headed by Director and assisted by Special Director, tenure 2 years by CVC Act 2003. It functions under the aegis of the Department of Personnel, Ministry of Personnel, Pension and Public Grievances, Prime Minister's Office, PMO. Its role is to prevent corruption and maintain integrity in administration. It works under the supervision of the CVC, Central Vigilance Commission, in matters pertaining to the Prevention of Corruption Act, 1988. It also investigates the cases connected to infringement of economic and fiscal laws, i.e., breach of laws concerning customs and central excise, export and import control, income tax, foreign exchange regulations. These types of cases are taken up by the CBI either at the request of the department concerned or in consultation with the concerned department. It can begin a probe under certain circumstances if a state government makes a Central Vigilance Commission. Established in 1964 by Executive Resolution but CVC Act 2003, force passed on recommendation of Santhanam Committee in 1962. Designated as the agency to receive and act on complaints or disclosure on any allegation of corruption or misuse of office from a whistleblower. Apex business institution comprising Chief, Vigilance Commissioner and not more than 2 Vigilance Commissioner, appointed by President warrant under his hand and seal for 4 or 65 years, on the recommendation of 3-member committee. Comprising PM, Minister of Home Affairs and Leader of Opposition. Not eligible for further employment. Salary and allowance similar to the UPSC. The President can be removed on recommendation of the Supreme Court after inquiry on grounds of proven incapacity and misbehavior. The CVC receives complaints on corruption or misuse of office and to recommend appropriate action. Following institutions, bodies, or a person can approach to CVC, Central Government Lokpal whistleblowers. 79. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Request and the Union Government agrees to it if the Supreme Court or any High Court order the CBI to take up such investigations. It can take a case suo motu only in the Union territories. It is not an investigating agency. The CVC either gets the investigation done through the CBI or through Chief Vigilance Officers, CVO, in government offices. It is empowered to inquire into offences alleged to have been committed under the Prevention of Corruption Act, 1988 by certain categories of public servants. National Disaster Management Agency. Under Disaster Management Act 2005, NDMA, SDMA and DDMA were established. NDMA, Chairperson PM ex officio, Chairperson, and not more than 9 members, which are nominated by the Chairperson. Vice Chairperson Access Cabinet Minister, while other members are MOS. Apex body for disaster management and works under the Ministry of Home Affairs. Responsible for laying down the policies, plans and guidelines for disaster management and for ensuring timely and effective response to disaster. SDMA, under Disaster Management Act 2004. Chief Minister as ex officio, Chairperson and not more than 9 members. Chief of State Executive Committee is ex officio member. The state government also creates a State Executive Committee to assist the state authority in the performance of its functions and to coordinate action in accordance with the guidelines laid down by the state authority and ensure the compliance of directions issued by the state authority. Its powers and functions are almost a replica of the NEC at state level. DDMA, District Magistrate or Deputy Commissioner as Chairperson. Chairman of Zilla Parishad is co-chairperson. Not more than 7 members. Elected members of local authorities are ex officio members, but for tribal areas Chief Executive of District Autonomous Council is member. Maximum 2 members are appointed by the state who are district-level offices. National Investigation Agency. It was established in 2009 by NIA Act 2008. It is a central agency for investigate and prosecute offences which affect the sovereignty, security and integrity of India. It acts as the central counter-terrorism law enforcement agency without special permission from the states. A state government may request the central government to hand over the investigation of a case to the NIA, provided the case has been registered for the offences as contained in the schedule to the NIA Act. The central government can also order NIA to take over the investigation of any scheduled offence anywhere in India. The offences under the Atomic Energy Act, 1962, and the Unlawful Activities Prevention Act, 1967 are to be investigated and prosecuted by the NIA. Currently, the NIA has 9 branches besides specialized units. Recent amendment, the NIA Amendment Bill 2019 was passed by Parliament amending the original Act of 2008. The bill seeks to allow the NIA to investigate the following additional offences: human trafficking offences related to counterfeit currency or banknotes, manufacture or sale of prohibited arms, cyber terrorism, and offences under the Explosive Substances Act, 1908. Special NIA courts, for the trial of the cases registered at various police stations of NIA under Section 11 and 22 of the NIA Act 2008. Any question as to the jurisdiction of these courts is decided by the central government. These are presided over by a judge appointed by the central government on the recommendation of AT. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. The DDMA works as a district planning, coordinating and implementing body for disaster management. It will coordinate with the upper 2 tiers of the structure and will plan the implementation of the prevention, mitigation and preparedness at local level. The Chief Justice of the High Court with jurisdiction in that region. Supreme Court of India has also been empowered to transfer the cases from one special court to any other special court within or outside the state if the same is in the interest of justice in light of the prevailing circumstances in any particular state. The NIA special courts are empowered with all powers of the Court of Sessions under the Code of Criminal Procedure, 1973 for a trial of any offence. An appeal from any judgment, sentence or order, not being an interlocutory order, of a special court lies to the High Court both on facts and on the law. State governments have also been empowered to appoint one or more such special courts in their states. Miscellaneous. Elections. Articles 324 to 329 in Part 15 of the Constitution make the following provisions with regard to the electoral system in our country. Field Circle. The Constitution, Article 324, provides for an independent election commission in order to ensure free and fair elections in the country. The power of superintendence, direction and conduct of elections to the Parliament, the state legislatures, the office of the President and the office of the Vice President is vested in the Commission, UPSC 2017. Field Circle. There is to be only one general electoral roll for every territorial constituency for election to the Parliament and the state legislatures. Field Circle. The elections to the Lok Sabha and the state assemblies are to be on the basis of adult franchise. Thus, every person who is a citizen of India and who is 18 years of age, is entitled to vote at the election provided he is not disqualified under the provisions of the Constitution or any law made by the appropriate legislature, Parliament or state legislature. Field Circle. Parliament may make provision with respect to all matters relating to elections to the Parliament and the state legislatures, including the preparation of electoral rolls, the delimitation of constituencies. Field Circle. Article 323b empowers the appropriate legislature, Parliament or state legislature, to establish a tribunal for the adjudication of election disputes. Field Circle. Since 1998, the Commission has increasingly used electronic voting machines, EMVs, instead of ballot boxes. In 2003, all state elections and by-elections were held using EVMs. 81. Telegram, https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Field Circle. Electronic voting machine. An electronic voting machine, EVM, is a simple electronic device used to record votes in place of ballot papers and boxes which were used earlier in conventional voting system. Field Circle. Elections to the state assemblies are carried out in the same manner as for the Lok Sabha election, with the states and union territories divided into single-member constituencies, and the first-past-the-post electoral system used. Election laws. Representation of the People ACT, 1950. Field Circle. Articles 81 and 170 of the Constitution of India lay down the maximum number of seats in Parliament and in legislative assemblies of states. Field Circle. Article 171 of the Constitution of India lays down the maximum and minimum number of seats in the Legislative Council of a state. Field Circle. Representation of the People Act, 1950, was enacted to provide for the allocation of seats in the House of the People and in the legislative assemblies and legislative councils of states. Field Circle. The Act also sought to confer on the President the powers to delimit, after consultation with the Election Commission, the various constituencies for the purpose of elections to fill seats in the House of the People and in the legislative assemblies and legislative councils of states. Representation of the People ACT, 1951. Field Circle. The Act contains provisions relating to the following electoral matters: 1. Qualifications and disqualifications for membership of Parliament and state legislatures. 2. Notification of general elections. 3. Administrative machinery for the conduct of elections. 4. Registration of political parties. 5. Conduct of elections. 6. Free supply of certain material to candidates of recognized political parties. 7. Disputes regarding elections. 8. Corrupt practices and electoral offences. 9. Powers of Election Commission in connection with inquiries as to disqualifications of members. 10. By-elections and time limit for filling vacancies. 11. Miscellaneous provisions relating to elections. 12. Barring the jurisdiction of civil courts. Delimitation ACT, 2002. Field Circle Delimitation Act, 2002, was enacted to set up a delimitation commission for the purpose of effecting delimitation on the basis of the 2001 census so as to correct the aforesaid distortion in the sizes of electoral constituencies. Filled circle orders of delimitation commission cannot be challenged in court of law. Electoral reforms. Filled circle. The 61st Constitutional Amendment Act of 1988 reduced the voting age from 21 years to 18 years for the Lok Sabha as well as the Assembly elections. Filled circle. The use of electors' photo identity cards by the Election Commission is surely making the electoral process simple, smoother and quicker. A decision was taken by the Election 82. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Commission in 1993 to issue photo identity cards to electors throughout the country to check bogus voting and impersonation of electors at elections. Filled circle. In 1990, the National Front government headed by VP Singh appointed a committee on electoral reforms under the chairmanship of Dinesh Goswami, the then law minister. Filled circle. Recommendation enacted in RPA 1951. 1. A person who is convicted for the following offences under the Prevention of Insults to National Honour Act of 1971 is disqualified to contest in the elections to the Parliament and State Legislature for 6 years. 2. No liquor or other intoxicants are to be sold or given or distributed at any shop, eating place, hotel or any other place whether public or private within a polling area during the period of 48 hours ending with the hour fixed for the conclusion of poll. 3. The election would not be countermanded on the death of a contesting candidate before the actual polling. However, if the deceased candidate belonged to a recognized political party, the party concerned would be given an option to propose another candidate within 7 days. 4. Now, by-elections are to be held within 6 months of occurrence of the vacancy in any House of Parliament or a state legislature. Introduction of NOTA option. According to the directions of Supreme Court, the Election Commission made provision in the ballot papers, EVMs for none of the above, NOTA, option so that the voters who come to the polling booth and decide not to vote for any of the candidates in the fray, are able to exercise their right not to vote for such candidates while maintaining the secrecy of their ballot. The voters polled against the NOTA option are not taken into account for calculating the total valid voters polled by the contesting candidates for the purpose of return of security deposits to candidates. Even if the number of electors opting for NOTA options is more than the number of votes polled by any of the candidates, the candidate who secures the largest number of votes has to be declared elected. Table of precedence. 1. President 2. Vice President 3. Prime Minister 4. Governors of states within their respective states 5. Former Presidents 5a. Deputy Prime Minister 6. Chief Justice of India Speaker of Lok Sabha 7. Cabinet Ministers of the Union. Chief Ministers of states within their respective states Vice Chairperson, Niti Aayog Former Prime Ministers Leaders of Opposition in Rajya Sabha and Lok Sabha. 7a. Holders of Bharat Ratna Decoration. 8. Ambassadors Extraordinary and Plenipotentiary and High Commissioners of Commonwealth countries accredited to India. 83. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Chief Ministers of states outside their respective states. Governors of states outside their respective states 9. Judges of Supreme Court 9a. Chairperson, Union Public Service Commission Chief Election Commissioner Controller and Auditor General of India 10. Deputy Chairman, Rajya Sabha Deputy Chief Ministers of States Deputy Speaker, Lok Sabha. Members of the Niti Aayog Ministers of State of the Union, and any other minister in the Ministry of Defence for defence matters. 11. Attorney General of India, Cabinet Secretary, Lieutenant Governors within their respective union territories. Indian Constitution parts and schedules. Originally the Constitution contained 395 articles divided in 22 parts and 8 schedules. At present there are 448 articles in 25 parts, 12 schedules. The numbering still remains the same, but as and when the Constitution is amended, new articles are added below original articles with suffix A, B, C, etc. For example, when our Constitution was amended for adjusting the right to education, a new Article 21A was inserted below Article 21. Parts of Indian Constitution. Part Subject Articles. Part 1 The Union and its Territory. Art. 1 to 4. Part 2 Citizenship. Art. 5 to 11. Part 3 Fundamental Rights. Art. 12 to 35. Part 4 Directive Principles. Art. 36 to 51. Part EVA Fundamental Duties. Art. 51A. Part 5 The Union. Chapter 1 The Executive. Art. 52 to 78. Chapter 2 Parliament. Art. 79 to 122. Chapter 3 Legislative Powers of President. Art. 123. Chapter 4 The Union Judiciary. Art. 124 to 147. Chapter 5 Controller and Auditor General of India. Art. 148 to 151. Art. 52 to 151. Part 6 The States. Chapter 1 General. Art. 152. Chapter 2 The Executive. Art. 153 to 167. Chapter 3 The State Legislature. Art. 168 to 212. Chapter 4 Legislative Powers of Governor. Art. 213. Chapter 5 The High Courts. Art. 214 to 232. Chapter 6 Subordinate Courts. Art. 233 to 237. Art. 152 to 237. 84. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. Part 7 States in the B part of the first schedule repealed by Const. 7th Amendment, Act, 1956. Part 8 The Union Territories. Art. 239 to 242. Part 9 The Panchayats. Art. 243 to 243. Part IXA The Municipalities. Art. 243P to 243ZG. Part IXB Cooperative Societies. Art. 243H2. 243ZT. Part 10 The Scheduled and Tribal Areas. Art. 244 to 244A. Part 11 Relations between the Union and the States. Chapter 1 Legislative Relations. Art. 245 to 255. Chapter 2 Administrative Relations. Art. 256 to 263. Art. 245 to 263. Part 12 Finance, Property, Contracts and Suits. Chapter 1 Finance. Art. 264 to 291. Chapter 2 Borrowing. Art. 292 to 293. Chapter 3 Property, Contracts, Rights, Liabilities, Obligations and Suits. Art. 294 to 300. Chapter 4 Right to Property. Art. 300A. Art. 264 to 300A. Part 13 Trade, Commerce and Intercourse within the Territory of India. Art. 301 to 307. Part 14 Services under the Union and the States. Art. 308 to 323. Part XIVA Tribunals. Art. 323A to 323B. Part 15 Elections. Art. 324 to 329A. Part 16 Special Provisions relation to certain classes. Art. 330 to 342. Part 17 Official Language. Chapter 1 Language of the Union. Art. 343 to 344. Chapter 2 Regional Languages, Art. .345 to 347, Chapter 3 Language of the Supreme Court, High Courts, and so on, Art. .348 to 349, Chapter 4 Special Directives, Art. .350 to 351. Art. 343 to 351. Part 18 Emergency Provisions, Art. 352 to 360. Part 19 Miscellaneous, Art. 361 to 367. Part 20 Amendment of the Constitution, Art. 368. Part 21 Temporary, Transitional and Special Provisions, Art. 369 to 392. Part 22 Short Title, Commencement, Authoritative Text in Hindi and Repeals, Art. 393 to 395. Indian Constitution Schedules. Indian Constitution originally had 8 schedules. 4 more schedules were added by different amendments, now making a total tally of 12. Schedules are basically tables which contain additional details not mentioned in the articles. Indian Constitution Schedules 1 to 12. 85. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. 1. First Schedule, the list of states and union territories and their territories. 2. Second Schedule, provisions of the President, Governors of States, Speaker and the Deputy Speaker of the House of the People and the Chairman and the Deputy Chairman of the Council of States and the Speaker and the Deputy Speaker of the Legislative Assembly and the Chairman and the Deputy Chairman of the Legislative Council of a State, the Judges of the Supreme Court and of the High Courts and the Controller and Auditor General of India, the list of states and union territories and their territories. 3. Third Schedule, the forms of oaths or affirmations. 4. Fourth Schedule, provisions as to the allocation of seats in the Council of States. 5. Fifth Schedule, provisions as to the administration and control of scheduled areas and scheduled tribes. 6. Sixth Schedule, provisions as to the administration of tribal areas in the states of Assam, Meghalaya, Tripura and Mizoram. 7. Seventh Schedule, the Union List, State List and the Concurrent List. 8. Eighth Schedule, the list of recognized languages. 9. Ninth Schedule, provisions as to validation of certain acts and regulations. 10. 10th Schedule, provisions as to disqualification on ground of defection. 11. 11th Schedule, the powers, authority and responsibilities of panchayats. 12. 12th Schedule, the powers, authority and responsibilities of municipalities. 86. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,779,726,117. IAS Network. Prelims 2023 Test Series. Download app, directly enroll in the app. https://play.google.com/store/apps/details. id = co. Evan. MXDBX. 87. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,729,726,117. 88. Telegram. https://t.me/IAS Network website, www.IAS Network contact, 9,729,726,117. 89. 2021 Toppers Testimonials. Rank 41 Sonali Dev. Rank 78 Survey. Rank 156 Pratik Agarwal. Rank 235 Aswin Kakumanu. Rank 441 Faisal Raza. Rank 509 Kumar Aj. Rank 586 Rishav Hans. Rank 644 Sparsh Verma.